Mr. Birnbaum, Mr. Price, before we do anything else, we need to consider the question of whether any reporting restrictions are needed. We considered that for the purposes of the directions hearing in October last year, and no restrictions were imposed. But this is now the substantive hearing of the appeal. The proceedings are being recorded, and although it's not a live transmission, in general terms, there would be liberty for that to be broadcast at any time from today onwards. And in the ordinary way, of course, members of the press are entitled to send live communications from court as the hearing develops. So we need at the outset to address the question of whether either of you suggest any reporting restriction is necessary. It may perhaps boil down to a question of whether one of the several possible outcomes of the appeal could be an order for a retrial. Speaking for myself, it's difficult to see what other need there might be for reporting restrictions, but I'll hear what each of you have to say. Mr. Birnbaum.
Lord, there has already, as you will be aware, I think, been very considerable publicity to this matter, including in recent days. For my part, I cannot think of any reason why there should be any restriction now.
Right, thank you. Price.
My Lord, I can identify a route by which one might end up with a retrial, as my Lord has mentioned. But at this stage, I don't feel able to submit that it would warrant a restriction on publicity.
Well, the question would be, in terms of the legislation,
yes,
whether in the hypothetical event of the appeal succeeding to the extent of the conviction being quashed and a retrial ordered, whether in that situation there would be a substantial risk of prejudice to the administration of justice in the retrial if there were publication of anything which might be said or will be said in the course of this hearing.
Yes. My Lord, as I say, I can't think anything that would impact upon the conduct of the hearing. It might need to be revisited when the court published its judgment, depending upon what that said. But at the present time, I seek to make no further submissions on the matter.
Thank you. No restrictions? No restrictions? Thank you both. Then, for the avoidance of any doubt, there are no reporting restrictions in place. Thank you. Yes, Mr. Birnbaum.
Lord, let me formally introduce counsel, if I may.
Yes.
As you know, I appear for the appellant Oliver Campbell, assisted by my learned friends, Mr. Glyn Maddox, Honorary King's Counsel, and Miss Rose Slowe. I will have a word to say about the unusual disposition of defence counsel, appellate counsel in a moment, if I may. My learned friend, Mr. John Price, King's Counsel, assisted by Tim Hunter, respond.
Yes.
I should say that the Commission is represented here today by its Director of Communications. Oliver Campbell, who, as you know, is cognitively impaired, is here. He will not understand very much of these proceedings, I think, but to assist him discreetly to follow, his former MP, Mr. Sandy Martin, is here and sits next to him.
Thank you.
The Lords, trying to begin a summary of this remarkable case, one should begin by reminding the court that Oliver, as I will call him if I may, was convicted on the 10th of December of 1991, then aged 21, at the Old Bailey before Mr. Justice Turner of the murder of Baldev Hoondle and of conspiracy to rob. He was sentenced to life imprisonment. His friend and co-defendant, Eric Samuel, was acquitted of murder but had pleaded guilty to conspiring to rob with Oliver. That is a fact which the respondents strongly rely upon, as you know. His appeal was dismissed on the 30th of June of 1994. A first application for referral of his convictions was rejected by the Criminal Cases Review Commission in February 2005. An attempt to obtain permission for judicial review of that decision was unsuccessful, the court finding that the decision was lawful and within the powers of the Commission. The second application was made again in 2019, and the Commission has now referred the case back to this court. Thus, unlike the recent case of Malkinson, this case comes before you after the first application to the Commission was dismissed. But I think I should say at the outset, in fairness to the Commission, that this is not a case where the Commission can be criticised for having failed to make inquiries. Indeed, as we see it, it conducted a very fine and thorough investigation of the case in the early part of this century and actively sought out fresh evidence on the second application. We submit that, sadly, it drew the wrong conclusion in deciding not to refer the case nearly 20 years ago. However, Oliver Campbell's many supporters did not give up at that time. They included, I should say frankly, myself and other lawyers as the author of the first application, a solicitor called Susanna Arthur, whose name you may not have seen in the papers, but she was the first to be consulted by Oliver in the late 1990s, and Mr. Maddox, who took over from Susanna Arthur as Oliver's solicitor. There were also BBC journalists who made a very fine film in 2001 called If the Cap Fits, arguing the case that he'd been wrongly convicted, and a number of other investigative journalists. But it was not until the 17th of July 2019 that there was, from our point of view, a breakthrough. On that day, there was a debate in the Commons about the work of the Commission, and Mr. Martin, who was then MP for Ipswich and who'd known Oliver for many years, made a powerful speech criticising the Commission for not having referred the case on the first application. That led eventually to contact with Helen Pitcher, the chair of the Commission, as you know, and we are grateful to her for taking a personal initiative in ensuring that this case was looked at by the Commission for a second time. You will be aware from your reading of the papers that Oliver had suffered severe brain damage as a baby of 8 months. His intelligence is borderline defective, with an impaired capacity to process or remember more than the simplest verbal information, severely restricted reasoning skills, and poor concentration and memory. At the time of the police investigation, neither the police nor Oliver's solicitors had more than a vague idea of the extent of his mental disabilities. They were better understood at the time of the trial in 1991 and of the appeal in 1995. But significantly, it was not until 2003 that a psychologist instructed by the Commission, Dr. Susan Young, used the latest psychometric tests to discover and record the full extent of his disability and vulnerability. Mr. Hoondle had been the proprietor of an off-licence at 155 Lower Clapton Road in Hackney. At about 10:35 p.m. on Sunday, the 22nd of July, 1995, 2 black men attempted to rob that shop. Baldev was shot in the head at point-blank range by one of the 2. The gunman wore a distinctive baseball cap bearing the legend British Knights. The 2 ran away and each discarded an item of clothing in a small street nearby called Arrows Court, a few hundred yards away from the shop, no doubt to make detection more difficult. The gunman threw away the cap, and his accomplice, who we can be sure was Eric Samuels, threw away his jacket. The Crown case was that Oliver was the gunman and Eric his accomplice. The evidence against Oliver was that he was undoubtedly the owner of the baseball cap, which he had bought little more than a week before the crime. There was a very weak identification by a passerby, Mr. Purchase, who had briefly seen the escape of the robbers. The crucial evidence was a series of admissions made in the absence of a solicitor, which we submit were largely inconsistent with the known facts and/or self-contradictory or simply ridiculous. The few points about which Oliver was right, he could well have heard from Samuels or from other sources, such as media reports, or even from police, who spent a great deal of time with him when no tape recording could be made. It's fair to say that defense counsel at trial labored under three great disadvantages. First, experts Dr. McKeith, a psychiatrist, and Dr. Johnson, a forensic psychologist, had considered Oliver's case. Although they were critical of the police interviews as being oppressive, they had been unable to suggest any reason why Oliver might have confessed falsely. Secondly, defense counsel were unable to call cogent evidence that Eric, on the 15th of December 1990, shortly after being charged, had exonerated Oliver to a police officer called Detective Sergeant Cater. At that time, Eric said that he committed the robbery with another man whom he called Harvey, who had stolen Oliver's hat from him, taken it from him, shortly before the robbery. We refer to Eric's confession as the Harvey admissions. The prosecution, very fairly and properly, had been intending to call those admissions as part of their case, but they decided to do so at the last minute because counsel for Eric objected to them as inadmissible. Under the law as it then was, and your lordships will appreciate this, but the public might not, the defense of Oliver had no right to bring out the fact that Eric had exonerated him because it was regarded as inadmissible hearsay. However, they would have been entitled to do so had Eric given evidence and had he denied making those admissions to Mr. Cater, but Eric did not give evidence. So by not giving evidence, Eric effectively prevented the jury from hearing the very evidence that might have exonerated Oliver. I hasten to add that, as you know, such a thing could not happen today because as a result of changes in the law of hearsay made by Parliament in 2003, today the court would have ample power to allow Oliver's counsel to call the evidence as part of their case. And I can develop that later. The third disadvantage defense counsel labored under is that Oliver, as the records show, was simply unable to do justice to himself in the witness box. His solicitors had very patiently gone to great lengths to prepare his defense. These days, special measures would be taken to assist Oliver to follow the trial and to give evidence. Ms. Slowe will explain them briefly to you after I've made my submissions. But none of that was available back in 1991. He might therefore well have appeared to the judge and the jury to be a liar when he was simply a mentally challenged young man, completely out of his depth and unable to cope with the pressure of giving evidence in what is probably the largest and most potentially intimidating courtroom in the land, Court 1 at the Old Bailey. I repeat what we have said in our appeal argument and at the directions hearing, that whilst the case might have been conducted somewhat differently by the defense counsel, we are not seeking to argue any criticism of them as a ground of appeal. And so briefly, to the basis of the referral, it is on three grounds: that there's fresh expert evidence unknown at the time of the trial or appeal from two forensic psychologists, which establishes a real possibility that the court may now find his admissions unreliable. As you will appreciate, one of those psychologists is Professor Johnson, who's changed his view in the light of the developments in the science relating to false confessions. Then the Commission thought that applying modern standards, Oliver would now be regarded during the trial process as vulnerable, and there's a real possibility that his admissions would be excluded. And thirdly, evidence that Eric had exonerated Oliver, both to a police officer shortly after his arrest and to a BBC journalist in 2001, a point to which I shall come, those exonerations might now be received by this court, although the Commission did not consider that this evidence would constitute a standalone ground. In addition, we, as you know, rely on a number of further grounds, most of which we argue are related to those three grounds of referral. I will analyze them and explain how we put them briefly at the end of my submissions. We contend that there are ample grounds on which you could find these convictions to be unsafe. In this regard, the very age of the convictions is helpful to our argument. On such matters as the right to a solicitor, or the fairness of the summing up, or the conduct of the police towards a suspect, current legal standards and practice are more favorable to the defendant than was the case in 1991, and those are the standards which, as I understand the authorities, you will apply. There is therefore, we contend, ample basis upon which you could find the conviction unsafe without entering into any controversy about whether Oliver is guilty or not. We go much further than saying that the conviction is unsafe. We say that Oliver is innocent. Yes, my lord.
Just one moment. You've referred interchangeably to conviction in the singular and convictions in the plural.
Sorry, to conviction and, I'm a bit deaf, sorry.
You've referred interchangeably to conviction in the singular and convictions in the plural. Which is it?
Oh, sorry. Yes, convictions, because he's convicted, of course, of two offences. Thank you for reminding me. Yes. The argument for Oliver's innocence in relation to both offences, and of course they, I think, stand or fall together, is based on three factors: description, coincidence, and the recent expert evidence. Description, we say that in important respects he did not fit the description of the gunman. He was both younger and at 6'3" much taller than the man described by witnesses as wearing the famous cap. And he was not picked out at the parade by the son of Mr. Hoondle, who, as I shall demonstrate in a few moments, was within feet of the gunman and literally face to face with him for a significant period of time in excellent lighting conditions, and interestingly, in a photo fit, was able to produce an excellent likeness of the British Knight's cap. We shall look at that. The coincidence is this. We say that there is a truly remarkable coincidence of three strong pointers to innocence, and they are: one, the nonsense and inconsistency of his admissions to police; two, the fact that, as we now know, Eric exonerated him not only to Mr. Cater, but to at least 5 other people, including his own trial solicitor and a BBC reporter, over a period of more than 10 years. And thirdly, the simple fact that hairs in the hat could not have come from either Oliver or Eric. Then expert evidence, and as your lordships know, this is rather complicated, and may I say that tomorrow I shall endeavour to call it quite shortly in a way that I will explain to you presently. But it is complex. The case for his innocence is buttressed and reinforced by the recent expert evidence on which the Commission relies. So let me outline briefly the circumstances in which the admissions came to be made, and I think doing it now will save time later. The admissions that we will have to consider are on 4 occasions. First at Slowe police station shortly after arrest, Secondly, at Hackney police station, in each case those admissions made in the absence of a solicitor. Secondly, words that could be construed as an admission, but were not, we submit, to his solicitor's representative at Hackney, and then, on one occasion, to a prison doctor. The interviews began in the early morning of the 30th of November at Slowe police station. There he was interviewed in the absence of a solicitor or an appropriate adult. D.S. Butters, a police officer ignorant of the true facts of the case, suggested to Oliver that he dropped his flat in the shop, a suggestion to which he agreed. So he'd admitted something that had not happened, but he then went on to admit being the lookout for the gunman, although at the end of that interview, he apparently, as one will see when we look at it in detail, withdrew that admission. Then, when police realized that he was somewhat backward, as a police report put it, he was interviewed in the presence of a solicitor and an appropriate adult by two officers, Ellison and Valden. The detectives were plainly convinced that since he was the owner of the hat and had admitted a presence on the robbery, he must have been the shooter, and they were determined to get him to admit that fact. They lied to him in suggesting that they had lots of witnesses against him, when in fact there was only one, a girl called Carla who had sold him the hat. They rang the changes between suggesting that the shooting could only have been deliberate and insinuating that it might have been an accident. D.S. Ellison suggested to him that his body language was that of a guilty man and bullied him. He also went out of his way to create opportunities, we say, to talk to Oliver off record when no tape recording could be made. The interviews continued on the 1st of December. Oliver denied any involvement, but again made remarks showing that he knew something about the robbery. In an interview which ended just before 6 p.m. on the 1st of December, he was represented for the first time by Arthur Mullinger, a very experienced and canny local solicitor, who protested during the interview about what he saw as Ellison's unfair interviewing tactics. Mullinger left the police station just before 7 p.m., expecting that he would be contacted by Ellison if it was possible to find a social worker to attend an interview that night, in which case Mullinger would make himself available. Ellison then arranged to interview Oliver in the absence of a solicitor, and he arranged that his foster mother should come to the police station, Mrs. Jackson, to act as an appropriate adult. Although the trial judge declared himself satisfied that Ellison had behaved impeccably, we say that evidence the judge did not hear shows that Ellison manipulated events so as to be able to hold an interview in the absence of a solicitor. In a further interview starting at 8:30 p.m. or just after on the 1st of December, Oliver admitted to being the gunman. He tried to say that the gun had gone off accidentally, which was, of course, exactly what the police had been encouraging him to say. The admissions he made were in many respects inconsistent with one another and all the known facts, and some were simply absurd. For example, he claimed to have hired the gun together with a number of bullets, although he did not remember where he'd hired it from or for how long. He first said it was hired for 2 weeks, and then for 2 months. He'd practiced with it and had hidden it, but was unsure whether he'd done so in a field or a forest. Having first indicated that he fired with his left hand, and he is heavily left-handed, he then said he'd fired with his right. He claimed to have carried the gun in some sort of holster, which he'd made under his left arm using 2 bits of string. He had to untie the string to release the gun in the shop. This interview was too much for Mrs. Jackson. She said that she felt sick and it was abandoned so that she could go to the toilet. The most unlikely part of this story was the string holster under his left arm. He was heavily left-handed. Anyway, the idea of a string holster is surely a nonsense. And there's expert evidence acquired by the BBC in 2002 from a neuropsychologist, Dr. Legg, that he could not have managed the tying and untying of the string holster with his right hand. Anyway, if he'd done anything like this, Mr. Hoondle Jr., who was within feet of the whole incident, would have seen it. And what's happened to the pieces of string, one might wonder. When he next saw his solicitor's clerk, whose name was Mrs. Eldridge, the next day, after the interview, Oliver repeated the story about an accidental shooting, but added another detail that was untrue, that some money had been taken. In fact, nothing was taken. Mrs. Eldridge, when she wrote up her notes, commented that it was unclear whether he was confessing or telling a story as if on TV, her phraseology. Shortly after being remanded in custody, I think to Feltham, he appears to have told a prison doctor that both he and the other man had guns, even though this seems incredible for an attempted robbery of a supermarket where there would be no security. And it's impossible to reconcile that with what he'd told the police, to whom he'd made clear that his accomplice was unarmed. So we say, and this is the nub of our submission on this point, that taken as a whole, the admissions Oliver made are a litany of inconsistency because they contradict one another, inaccuracy because most of them are contrary to the known facts, and sheer absurdity. We will play excerpts from the two crucial interviews where he made admissions in order to illustrate these points and to show that as a whole they are incredible. Next point, major point in our coincidence, exonerations. They are, as I say, over a period of over 10 years, starting with D.S. Cater and ending in an interview in 2001 with the BBC reporter Linda Cowell, which was covertly recorded. The account that he gave to Cater that we will have to look at in some detail, recorded in a note that Cater, who must have had a remarkable memory, made soon after, is, in contrast to Oliver's accounts, both credible and, we say, cogent. We ask, if it's untrue, why did Samuels go on to acknowledge that Oliver was innocent, even though he had pleaded guilty to conspiracy to rob with him? We say that he pleaded guilty to save his own skin. We acknowledge that he was never willing to repeat to the Commission his exoneration of Oliver, but there are strong indications that he was concerned about repercussions from the true gunman and about the possibility of being further prosecuted, unrealistic though that might have been. Moreover, understanding his motivation is made the more difficult because by the early noughties, he was an inpatient at a psychiatric hospital. We do not know what his condition was or the regime under which he was in the hospital, but we will see from the interview with Linda in 2001 that by that time it was fairly relaxed, and indeed at the time of the interview he was visiting his mother, allowed to go to 10-pin bowling and that sort of thing. But he was a psychiatric patient. One will have to consider the balance of credibility, and it may be useful to the court if I indicate how I will put it. We say the more incredible Oliver's confessions, the more credible are the exonerations of him by Eric, and vice versa. More specifically, sometimes guilty people, when they confess, may lie, fantasize, or make mistakes about what actually happened. But the fact that Eric Samuel gave such a convincing account of having committed the offense with another person, not Oliver, powerfully suggests that the reason for the nonsense of Oliver's confessions is simply that he was not there and did not know the detail of what had happened. The third element in the coincidence is very simply that there were 4 black hairs in the hat, which could not have been those of either Oliver or Eric. Given that he had purchased the hat only a week before, we say, in the light of the other matters I've mentioned, that there's a very strong inference that those hairs must have been the hairs of the true gunman. I confess that there is no one factor here which proves innocence. For example, there is no exculpatory DNA, as there has been in other recent cases. Rather, I will seek to put before the court a combination of facts so compelling that, taken as a whole, they prove that Oliver cannot be the man who shot Baldev Hoondle. A word about expert evidence, if I may, and your lordships will have delved into the not inconsiderable new evidence that there is. Since the case went to appeal in the mid-90s, there has been what I would call a slowly growing crescendo of concern among forensic psychologists that Oliver might have confessed falsely. There was opinion from Miss Tunstall, a forensic psychologist at the time of the appeal, pointing out, amongst other things, the vulnerability of Oliver and suggesting that he did not understand the caution. In 2001, Professor Brian Thomas Peter was the first to consider in any report the admissions in detail and to try to relate them to Oliver's personality and vulnerabilities. He concluded that the police had questioned him in an oppressive and domineering way. He might, Thomas Peter thought, have confessed falsely because he thought he'd been convicted anyway and because the consequences of conviction would be less severe if he said that the shooting was unintentional. The Commission very helpfully asked Johnson in 2003 to review that report. He agreed with the criticisms of police conduct. He accepted that the instrumental compliant false confession theory, as it's called technically, might be correct, but he'd not seen any evidence to support it. He criticized aspects of Thomas Peter's approach as based on common sense rather than, as he put it, rigorous psychological theory. Professor Johnson now accepts, many years on, that in his earlier reports he'd not understood the full extent of Oliver's vulnerability and had focused too narrowly on his suggestibility, his background, and rather than thoroughly examining his tendency to be compliant, his background, and his communication difficulties. He now thinks that the risk of a false confession was more than 50%. Dr. Peck supports his conclusion, although her reasoning is somewhat different, and we'll look at that tomorrow. The consensus of experts now is that Thomas Peter was probably right in his view that Oliver decided after pressure from police that confessing to an accidental killing was the least bad option. I've referred to changes in the science relating to false confessions. May I give you what you might find a simple and interesting statistic? In the references section to the report of 7th of October 2021, Professor Johnson lists 56 publications, of which 26 were published in 2004 or later. In other words, after the last report, for the purposes of the first review. So virtually 50% of the literature the professor regards as relevant was published after he last reported on the case in 2003. And of course, this court, in its various divisions, the Court of Appeal, is always very concerned when a new light is shed on previously considered facts by new scientific developments. As you are aware, there is no report from any prosecution expert. I have to say, with all respect to distinguished counsel on the other side, but we are somewhat baffled by the way that they have approached this case. We had been confident that they would, at the very least, obtain one report, but they haven't. And they seek to argue that you're not entitled to consider any of the new expert evidence because it's all inadmissible, and because, in effect, I put it colloquially, it usurps what would be the function of a jury. We will seek to argue tomorrow, I think, it will be tomorrow, that that is a misconceived legal submission. But there is a fundamental point of common sense and fairness here, that the respondent's approach is unfair and foolish, because for all they know, any reputable expert would now agree with the views of those we seek to call that the risk of Oliver having confessed falsely was high. They have no idea whether the evidence that they're seeking to exclude from your consideration may be right or not. It is also somewhat unclear to us what view they take or what submission they make in relation to other important aspects. For example, we do not know whether they seek to defend the conduct of the police or whether they seek to defend any of these admissions as conceivably being true. And there are other matters that where we do not know what they will be submitting. No doubt that will become clear in the course of this hearing. A word about how I will present this case. There is, of course, a mass of paper here, much of it, I must confess, generated by us for the appellant. I will start with a few points about Oliver, his background and character. Then I will take you as briefly as I can through the photographs and plans so that you may understand the general geography. And then I will go through matters in more detail. I will try to hone down to the slimmest extent that detail. If I go too fast, please tell me. If there are matters that your lordships feel that you already have clearly in mind, then again, please tell me, so that we can focus on the points that will be of best assistance to the court. But the way that I shall do it is that after a general factual introduction, I will take your lordships right through all of the material where he has made or could be said to have made admissions, that is Oliver, and then I will go right through all of the material relating to the exonerations, because I think it will be helpful to the court to be able to think about that comparison as we go through. And then I shall deal briefly with other matters, such as what I would call expert reporting history, so that the ground will then be laid for Ms. Slowe to make her submissions at what I think will be late this afternoon, which will be brief, but I know cogent, in relation to the special measures that would be available to protect Oliver were he to be tried today.
Just let me pause there. I'm being distracted by what look like members of the public in the gallery using mobile phones. I don't know who here is an accredited journalist and who is not. But those who are not accredited journalists must obey the clear notices displayed throughout the court that mobile phones are forbidden.
Lord, thank you. May I mention a difficulty I am having? As I mentioned before, I am hard of hearing, even with these hearing aids. The acoustics in this court are very poor, and I'm having great difficulty in hearing, my lord. I don't know if anything can be done about that. It's not, of course, your fault. But perhaps we could bear that in mind.
My last observation was directed at
people
in the
heard
public
it.
gallery.
I heard it, yes, thank you.
Not
Thank you very much indeed. I think I ought to say, yes, sorry. I come then to Oliver's mental disabilities. Your lordships are familiar with the admission that was made about his mental disabilities at the trial, which we set out towards the beginning of our appeal argument. It is important, I think, however, to look in some detail at the report, or parts of the report, the conclusions to the report of Dr. Young, 2003, because that note goes much further than anything that was in evidence at the trial. And so,
is this the subject of a fresh evidence application?
No, it isn't. This is not at all. This is the report in 2003 that was before the commission that they commissioned, that they obtained in the first application, and which is referred to also in the statement of reasons and is relied upon in our appeal argument. And so can we go, please, to the conclusions section of that report, which Ms. Slowe will now bring up on the system for the court to look at.
Can I just respond to what you said about the acoustics?
Yes.
I'm afraid I'm struggling to hear you as well. I'm the furthest from you.
Yes.
So if you wouldn't mind just keeping your...
I think I'm speaking very loudly, my lord. That's the effect of the hearing. Is that better?
It is better, and I say...
Yes. Well, risking a sore throat, I will try to do that throughout. Yes. I'm sorry, Your Lord. Yes. Right. Have you got it there? Yes. Your Lordships, I think, need to log in to the electronic system.
There are only two lordships on this bench.
I'm so sorry.
I think that's...
Yes.
I think that's
my lords and my lady.
I think that's the 7th time.
Yes, I'm very sorry. I'm very sorry. I did not intend any offence, of course, but it was clumsy. Does the court have that?
Well, nothing has appeared on my screen so far. I don't know what has been sent. Which document do you want us to look at?
My lords and my lady, you should receive an invitation on the digital case system to go to the page that I'm viewing. If not, it's at page CACD 1, 1237.
Yeah, got it.
I think it's also at M348, I think, isn't it?
It's a statement of reasons.
Sorry? Yes. Yes. If the court has that, could you please
No,
go?
well, I don't. Just tell me what the document is, please, and then I can
It
find
is the report. It is the report of Dr. Young, the 2003 report of Dr. Young.
And it's which page in CACD 1?
It is page 13 of the report, which is part of her conclusions, where she summarises her view.
Yes. Where do I find the report, please, Mr. Birnbaum? What is the page reference within CACD 1?
I think
Unfortunately, the 2003 report wasn't copied in full, so you have to find it within the appellant's bundle. It's not available in full in the report section. It's available at CACD 1, page 600 to 601.
Thank you.
on my system, it comes up, I think, on a different reference at M, open brackets 3, close brackets 57, in the section M for the first 1999 application to the CCRC.
Is that right?
Yes, I don't think it follows, that document follows all the way through to the conclusions, my lady. The last few pages are missing.
The last few pages are in the bundle that we served, and I don't know why they are not in the original that's in the reference that my lady has referred to. Does the court have that?
Yeah.
Well, I don't, but I'll find it in due course.
Right. But
You
then let me
just say
read
what
to
you want
you.
to say about
Let
it.
me read to you what I rely upon as the main points. It is beginning at paragraph 5 of her summary. significant intellectual impairment. Compared with his intellectual abilities, he's significantly impaired in his immediate and delayed memory function, his ability to sustain attention, speed of processing, verbal fluency, and executive functioning. He falls at or below the first percentile compared with the general population on all the tasks that measured these functions. By contrast, his verbal and non-verbal reasoning abilities are a relative strength. And then over the page, he has difficulty with planning, sequencing, and organizing information. His problem-solving abilities were poor. He may approach difficulties without prior thought, planning, or appropriate strategy, resulting in haphazard approach and making multiple errors. Visual and verbal memory very poor. Most individuals learn through errors and repetition. He's also very disadvantaged in that respect, demonstrates very poor learning ability. When faced with things to do in which he lacks confidence or is unsure, he becomes confused and unsure how to respond. Then 4 lines down in paragraph 6, significant difficulty in verbal fluency and expression means he finds it difficult to say what he wants to say and gets his meaning across to others in social interaction. Very slow to process information, easily distracted, loses train of thought, becomes confused, becomes difficulty expressing himself, becomes very tired after long periods, sustaining concentration. Because of his abnormally poor ability in concentration, difficulty with complex or lengthy questions, and difficulty with complex or lengthy questions, and these need to be expressed in relatively simple language and broken down into small stages. Verbal fluency very poor, slow to process information. Tendency to give non-specific answers to questions and difficulty with providing concrete examples. When he's unsure of the answer, this is the end of paragraph 6, he's likely to give unrealistic, unreliable answers. And then she says, and this is important, additionally, Mr. Campbell attempts to cover up his problems. This is paragraph 7. In spite of being clearly very tired when asked directly, he denied this to be the case. He does not like to admit his problems and tends to minimize them, does not like to have them acknowledged by others. This is most likely due to his problem in verbal expression and the lack of confidence and ability to freely explain his difficulties to other people. And so, there for the first time in 2003 was information which would have been of huge importance to the police and those who attended the interviews and to the court of trial. May I ask, were your lordships able to find that document on the system? I'm sorry, was the court able to find that document?
I've got it.
Yeah.
Thank you.
In the papers, there was evidence that between the time of his injury at the age of 8 months and after a short period of care with his mother, he was cared for in various institutions by foster parents until 1986 and had intermittent contact with his natural mother. In 1986, Mrs. Jean Jackson started to look after Oliver in consultation with social services as his foster mother. In April 1989, he left home and moved into a flat at 239 Manor Road, Stratford, which he shared with a young man called Richard Lester. There are indications that his behavior started to deteriorate after he left the home of Mrs. Jackson. He got into a small amount of trouble with the police, such as criminal damage, which he claimed was an accident, and trying to break into a phone kiosk to steal money, though there was nothing of any great seriousness and all charges were dropped. As far as we know, and your lordships will have read these glowing references at the start of our appeal argument, Everyone who has known Oliver, either before his arrest or his release, speaks of him as naive, gentle, loyal to friends, not at all violent and easily manipulated. Why is that relevant to this appeal? First, because the modern approach of forensic psychologists is to take into account the personality of the person whose case they're considering, including early history and trauma. And as Dr. Beck explains at paragraphs 1929 to 31 of her report, modern standards, as she puts it, require a wider understanding of a person's personality and emotional world, what she terms a holistic view. Secondly, it is not just that Oliver was most unlikely to participate in a robbery, to carry a gun or to use it. We say that it's hardly likely that he would know where to get a gun illegally, that anyone would hire a gun to him, or that a semi-professional like Eric would choose an inexperienced man with Oliver's obvious mental disabilities as the gunman on an armed robbery. Those, we say, are matters of common sense. I will not take you to all of those references. You have read them. But the experts were particularly struck by evidence in the police and probation files, which I can take you to if you wish, which, as Professor Good-Johnson put it, and I think it's paragraph 245 of his report, these observations of his vulnerability are highly relevant to interviews where police used manipulation and pressure to overcome his resistance and denials. In other words, the ability whether he was able to cope with the pressure from police. So it goes to all of that, and that will be something that the experts will testify to tomorrow, I anticipate. Now, something about Eric, and this is at paragraph 50 and following in the appeal argument. He had a very bad record for offences of dishonesty and violence, sentenced to 2 years and 6 months imprisonment in August '85 for grievous bodily harm with intent and assault occasioning actual bodily harm. His girlfriend, Jacqueline Studd, described how he'd made her work as a prostitute in Commercial Road and would spend the money she gave him on drugs. He took tablets with his tenant's beer, became very aggressive. He had the nickname of Tenants. In April 1990, Eric was arrested and remanded in custody for an offence committed the previous day, an attack on a woman in Brick Lane. Significantly, he was released on the 13th of July, not long before the robbery, and on condition that he went to live with his father at an address at 12B Downs Road. He failed to report to police on the 23rd, the day after the shooting, and he was rearrested on the 24th. He was sentenced to a total of 2 years for attempted robbery, possession of offensive weapon, and breach of conditional discharge on the 5th of October. It was on the 13th of July that Jacqueline Studd, who had been living with him at an address called 6 Phillibrook Road that we'll look at a moment, parted company with him, and they no longer lived together. The report of a forensic psychiatrist, Dr. Bowden, and please indicate if you would like the system references to any of these documents, paints a picture of a disturbed young man with problems of alcohol and drug dependence, history of paranoia and delusions, believing that other people could read his mind and that they knew what he was thinking, of low average intelligence and an unreliable informant. Although this was very shortly before the trial, this report was dated the 2nd of November 91, he was unwilling to discuss the offence with Dr. Bowden. Dr. Bowden concluded that his symptoms might be those of paranoia. As I've said, by the time of the investigation by the BBC and the CCRC in the early part of the 21st century, Eric appears to have been a patient in various psychiatric facilities. I mention one other thing which you may not have realized because you may not have read the first statement of reasons, that it is recorded there at paragraph 151 that Dr. J. Smith, a consultant in forensic psychiatry, on the 3rd of July 2003, concluded that Eric would be able to understand questions put to him, and if required to give evidence, he would require quite a deal of support from staff and daily monitoring of his mental state in order to detect any signs of relapse. So he too would need help if he were to testify. We concede that the greatest care is needed before accepting the word of such a person. If our case is correct, one must face the fact that he lied by his plea of guilty to conspiring to rob with Oliver. We say that the evidence powerfully suggests, and we shall have to look at the account of a man called Sanderson in this regard, the evidence powerfully suggests that he pleaded guilty in order to save his own skin and to avoid having to go into the witness box. But he had a bad conscience about it, and there is irrefutable proof that he repeatedly told people over 10 years that Oliver was not with him on the robbery. And by 2003, when the CCRC was investigating, he was apparently concerned that the law on double jeopardy was about to change and that he might be prosecuted again for the murder. There is no doubt that these two men were friends, and there is evidence in the papers that they used to associate together in the West End. The British Knight's hat. The court will have gathered that it was sold to him by Carla Hills, a young woman who worked at Jubilee Sports in Stratford on the 14th of July. She recalled that he wore black boots and was walking with a limp, she said, because he said a car had run over his foot. The 14th of July, of course, was only just over a week before the date of the eventual offence. He often came into the shop calling himself Derek, and it seemed that the only reason was to tell her about parties and to ask her out. About a couple of weeks after she made her first statement, he came to the shop and told her, "The old Bill came round to see me about the hat, and I told them I ain't got it, I gave it to a friend." They chatted, and she asked him for his phone number, which he gave, and we know what it was, it's in the statement, and told her his name was Oliver Campbell. At trial, she gave a different account of what he told her. "Someone's been to see me about the hat I bought. I told them I'd given it away." Well, he clearly was not trying to conceal his identity, and indeed gave her his phone number and true name. We will see that in the conversation that Linda Cowell recorded in 2001, Eric told her that Oliver had told him about this visit to Carla and that he had told Oliver off for being so stupid. So now let us come to locations, which are of some importance in this case. And I hope now that the system will come to our assistance. I'm going to show you, first of all, two photographs of the outside of the premises. And it's important to understand this for two reasons. First, to understand the getaway route, and secondly, to understand the very small, well-lit area in the shop in which the offence took place, with a grandstand view afforded to Mr. Hoondle. So, we're about to see, is it flashing? Yes, it seems to be flashing on the monitors. I gather the cable in this court has given problems in the past. Well, that is the exterior of the shop from which the gunman would have run. We did do some experiments this morning, and the system was fine.
Always the way, Mr. Birnbaum.
It is, when you need it.
Works brilliantly until the moment you need it.
Yes, absolutely.
However,
Well,
we do have these photographs in your master bundle.
Yes, but I
Section
think we will probably
J1,
have the same problem.
Page 5.
Yes. Are we going to have the same problem? I think we will have the same problem, whatever we are seeking to show. But can anyone?
I was going to show two photos of the exterior of the scene, my lords, my lady. The first is at J1, page 5.
Yep.
The second has recently been uploaded. It's at CACD1, page 2205.
It may be, may I make this suggestion? It may be that someone can come and give us technical assistance. Let me go to something different that doesn't require any visual input to deal with the cause of death, which is of some importance in this case, and the way that he met his death. Would that be convenient to the court?
I'm afraid I'm just looking to see whether I have CACD 12205.
Well,
And I do. Yes, that's a nighttime scene.
that's...
Well, I mean, you go wherever you want, Mr. Birnbaum, but I think both my lord and my lady, like myself, have both those photographs available to us. I'm afraid they can't be seen on any
Right.
or generally visible.
Yes, those yes, what you're looking at, therefore, is a sequence with two photographs which show the outside of the premises, and I'm sorry. And that's the corner.
Sorry.
The distance from the door of the shop to the corner is just over 15 meters, so it's a short distance. And if you go into the door, the road on the left, that is called Row Hill Road, Row Hill. And then shortly after, you would come to Arrows Court, a small roadway through some flats. It no longer exists, but we can see where it was. I now want to show you the Crime Watch video for two reasons. First of all, because it shows very graphically the escape route, and secondly, because undoubtedly Oliver had seen it when it was broadcast on, I think, the 6th of September, 1990. So can we... it's being suggested to me that we may need a short adjournment to check the equipment, and I think that would be sensible.
All right, we'll rise. Let us know when you're ready.
Thank you very much.
Yes, Birnbaum.
My lords, first of all, I'm told I must shout at you in order to be capable of being heard by the public, so I will try to do that.
Okay.
Secondly, it's not that Miss Slowe has joined the prosecution, but she has to sit in this position in order to be able to have some control over the system.
Okay.
This is the Crime Watch video that I mentioned to you. It's just about a minute long.
The apparent senseless murder of a shopkeeper. Baldev Hoondle was the proprietor of G&H supermarket in Lower Clapton Road, Hackney, where at 10:30 p.m. on July the 22nd, he was fatally shot as two men entered his store and attempted to rob him. The alarm sounded as the attackers ran into Row Hill Road and Arrow Court. Then we believe they disappeared through Clarence Road and Downs Road into the Nightingale estate. Did you see them making their escape? During their flight, they dropped 2 clues. This unusual suede berry with the label Artwear, London and Copenhagen, and this baseball cap with the British Knights logo. The suspect wearing the beret is described as being West Indian, aged 22 to 30, 5'11", muscular, clean shaven with short hair. Suspect number 2 was wearing the baseball cap, again West Indian, also aged between 22 and 30, 5'11", well-built with short hair. If you recognise either of these men or their hats, please call us now.
Thank you. Now I'm going to ask that the escape route be played slowly and without the sound so that I can explain it in a way that will make more sense in relating it to the rest of the evidence. So, can we pause there for a moment? Can we pause there? Yes, thank you. The suspects have run into Arrows Court, which you can see is a sort of series of doglegs through an estate of flats. It's a road that no longer exists. So no doubt they have gone down there in order to get out of the public way. And then we'll see that they go into Clarence Road where they turn right. Pause there for a moment. A gentleman, pause there please, a gentleman called Mr. Gager was, as we shall hear, turning left into Arrows Court as they came out and he saw them. More of him later. We go on and we imagine them turning left into Downs Road, where it so happened that Eric's father lived at number 12B. And then they turn into the Nightingale estate, as we'll see, council estate. And then they're lost to the observation of anybody known to the police. I hope that's clear. If one pursued that route and went further north, one would very soon reach a station called Rectory Road Station, which is of some importance in the Harvey admissions. Do my lords have this very helpful bundle prepared by the prosecution?
Yes, thank you.
Would you look at that, please, and look first of all at the overview map. So, if you look, please, to the left, the long road that I'm pointing to, that's the A10, which runs north-south, virtually in that particular here, down towards the Thames. Then, can we just identify what the numbers are? Number 1 is the scene of the offence. Number 2 is Arrow Court. Number 3 is Plaistow Police Station. Number 4, Hackney Police Station, which is at the other end of Lower Clapton Road at number 2. Samuel's father's home, 12B Downs Road. Samuel's mother's home, Bannister House in Homerton. Mrs. Jackson's home, 27 Wortley Avenue. Jacqueline Studd's house, Phillibrook Road in Leytonstone, E11. Cambridge Heath train station, Rectory Road train station. Now let's just identify those that we suggest matter. You can see where numbers 1 and 2 are, in close proximity, the scene of the offence and Arrow Court. Number 5 is Samuel's father's home, 12B Downs Road, and we saw where Downs Road is. Number 10 is Rectory Road Police Station, slightly further to the northwest. I mentioned that to you a moment ago. You will be interested to see, no doubt, where Samuel's mother lived. Eric's mother lived at number 6, Bannister House, in Homerton. So, and this is, of course, just a coincidence. It so happened that his parents lived, in effect, on either side of the scene of the crime and within fairly close proximity to it. Mrs. Jackson's home we needn't trouble about at the moment, but Jacqueline Studd's home is of importance because that is about 3 or 4 miles away, number 8 in Leytonstone, not in Dalston. The difference will become of importance in a moment. We can see where Dalston is because if you look back to number 4, which is Hackney Police Station, do you see Dalston Lane just to the left? So the area that we're describing, which includes the homes of the parents of Eric and actually the scene of the crime, could be described as Dalston. And we'll see the significance in a moment. If we go to the next plan, I'll keep my voice up. Map of E5. We can see more clearly now where the Shop and Arrow Court are, and the number 5, the home of the father of Samuels. You will see, and I should in fairness call attention to this problem. Downs Road is marked there next to number 5. And there seems to have been some confusion between that road, which they undoubtedly ran down, and Downs Park Road. If you go down Clarence Road and you find Sladen Place and the Church of God just to the left of it, then you'll see the name Downs Park Road just to the left where I am pointing. And there's a confusion in the statement of Mr. Gager, which I shall have to explain to you as a matter. And that, I think, is all we need, except just to note that there is the mother's home in Bannister House, tucked away just towards the bottom right of the large-scale plan. Now, the scene of the crime, as it were, and can we just look, if the system will allow us, at the plan of the area outside number 155. Here it is. And you can see where 155 is, and you can see where Roe Hill Road is. As I've said, if you use the scale and you measure from number 155 to the corner of Roe Hill Road, it's just over 15 meters. And the road, if you were standing on the other side of the road, which is where Mr. Purchase appears to have been, the identifying witness, it's a large 4-lane carriageway, and one can measure that one would be about 20 meters away from the entrance. A significant, but not a huge distance. Then, can we look, please, at the plan of the interior of the shop? Now, the area with which we're concerned is actually a very small area indeed, because you see the counter there, and there's a till. It may be difficult to read that. There we are, thank you. Hardip was standing, the witness was standing behind the till, and the action took place in front of him. In other words, in that little corridor between the till and the shelves that we see, which are marked selling various products, and then into the doorway, which would have been to his left. And one can work out very readily that the counter area is just over 6 feet wide. In other words, from the back of the counter to the front of the counter would be 6 feet, and that the area between the front of the counter and the beginning of those fixtures is only 4 feet. In other words, it's a typical local supermarket stuffed full of goods and with not a huge amount of room in which to move. The photographs of the shop, please. Thank you. Can we go to the door first? Yes. The door is just to the bottom, as you can see there. And you can see blood. We are not sure what the large black object is on the onions. Conceivably, it's the turban of the unfortunate Mr. Hoondle, but that could be an entirely ignorant guess. We don't know. You'll see the blood stains. Thank you. And can we just go back to see the multicolored hat? More of that in a moment. But the bloodstains tell their own tale, I think. And then let us go on through this sequence. Thank you. Next one, please. Now we're coming towards the counter, which would be on the left of the photograph as we look at it. There is the hat in more clearly. It's not clear how it got there. As the judge said to the jury, it was an unsung mystery, the way he put it, as to whose hat that was. Although conceivably it might have been the hat of Eric Samuels if he lost it very early on in the incident. But we can't be sure. Can we see the counter area, please? Now there we are, in front of the counter, behind which Mr. Hoondle was standing. That flap is up. Can we go on? Yes, that gives you a good idea of the distance between the counter, a narrow distance, and the fixtures. And there is no doubt, as we shall see in a moment, that the gunman was for a significant period facing Mr. Hoondle across his counter, a matter of feet away from him in what he described as well-lit conditions. I think that may be the last photograph. Yes, thank you. There's another useful view a little further to the left of the counter. Thank you very much. So now to the robbery. And I'm going to ask you to look at a transcript of Hardip's statement, because we realized the original was very hard to read, and we thought this would be useful to you, and you should have had it, I'm afraid, rather late, probably late on the weekend. And we've tried to highlight the bits where he describes the incident and the gunman. Do your lordships have that? If not, I think we can put it on the screen.
Well,
Can we do that?
I have it. It arrived very recently.
The digital case system reference, my lords, my lady, CACD1 at pages 2232 to 2234.
Thank you.
Thank you very much. So Hardip said, if your lordships had that, at about 10:30 we decided to close the store, and my father and Baldev, their assistant, to go outside and close the shutters. At this stage I was standing behind the main counter, which is situated to the right of the front door as you enter the store. My father was standing to my left about 6 feet away, and he was roughly the same distance from the front door. I cannot remember hearing whether Baljinder closed the front doors or not. It was now that two coloured men entered the store. One of these men approached the counter. I was standing behind, and he asked me for cigarettes. I remember there being a can of Tennant's on the counter, but I cannot be sure whether the coloured man picked this up from the shelf and brought it to the counter with him, or if I handed it to him from the cold drinks cabinet, which is behind the counter. This coloured man, of course, is Eric Samuel, Tennant's. Without picking up a single item, without saying another word, he walked out the front of the shop. After the first coloured man had left the store, the second man approached the counter. He asked me for the price of a bottle of Martell brandy. I hadn't seen where he'd approached from within the store, as I was focusing on the first man. I looked him straight in the eye. I immediately sensed that there might be trouble. Fearing this, I said to my father in Punjabi, "Be careful, there looks as though there might be trouble." My father made no reply, but I knew he understood what I had said. This second man just stood by the counter for a good 10 seconds, looking in my direction without saying a word. I then heard a noise by the door, which caused me to look round to my left, and I saw Baljinder being bundled into the shop. I saw a coloured hand come into contact with Baljinder's body, and I knew he was being pushed back inside. Almost immediately, I feared that the store was going to be raided, so I pressed the panic alarm, which is beneath the cigarette kiosk behind the counter. The alarm was activated straight away, and this is indicated by a light flashing outside the shop and a loud siren which can be heard from both inside and outside the shop. Having activated the alarm, I looked over towards the door and saw my dad and the second man struggling with each other just inside the front door. I could not see Baljinder or the first man. There were no punches being thrown or kicks. They both had their arms around each other and were struggling. The struggle only went on for a matter of seconds. It was then that I noticed that the coloured man was holding something silver in his hand, which was near my father's head and neck. Nothing was said between the two. There were no threats, and all I heard was a bang, it should say. It wasn't a loud bang. I would describe the sound as being similar to when a cap gun is fired. This all happened so quickly that I'm unable to say where this silver object appeared from. 1 second they were struggling, and the next I heard the bang, and my father fell to the ground. The coloured man ran out of the shop. I cannot say which direction he ran to. I ran from behind the counter to where my father was laying. I noticed he was bleeding from the neck. And then he gives a description of what he did to try and help his father and find the police. He then says, all the incidents which occurred inside the shop were clearly visible as all the internal lights were switched on in the corner where the incident occurred. Then the description of the second man. The man who was involved in a struggle with my father I would describe as follows. Possibly slightly older than the first. He was again West Indian, and I think slightly darker skinned than the first. He was about 5 inches tall, of large build. He wasn't particularly muscular or fat, he just seemed quite big. His face was a bit rounded, he didn't have any point to his chin. I think he had thick eyebrows. When he stared at me, I noticed his eyes were dark brown. He had some stubble on his chin. When he first came into the shop, I noticed this man was wearing a black baseball cap. It had the trade name British Knights on the front, I think in silver. I think the cap had checkered boxes as well. His clothing was very much the same as the first man's. I don't mean identical, but he was wearing dark clothing, nothing flash or fancy. Wearing some sort of jacket. Because of the height of the serving counter, I'm unable to describe any of his lower clothing or footwear. He only spoke briefly to ask the price of Martell brandy, but there was no obvious West Indian in his voice. His accent was British. So a very careful description, and we'll see in a moment the photo fit that he made, and we will be able to compare that with a photo of the actual British Knights cap. I can say definitely that I think I will recognize this man again. As I've said, it was this man who was holding the silver object in his hand during the struggle with my father prior to the bang, and my father falling to the floor. I can only say that all I saw was a glimpse of silver, and then I heard the bang, willing to help in any way. So, against that background, I want to take your lordship rather carefully to the evidence, the court, to the evidence about the cause of death. According to an admission made at trial, Mr. Hoondle's body was found at about 10:35 by emergency services. It was slumped in the doorway, as they put it. He was dead on arrival at hospital. The cause of death was a gunshot wound to the head. This is paragraph 72 of our appeal argument. There was a single entry wound to the left side of the head, passing through the left ear and the left side of the skull and ending in the region of the brain stem. The relative position of the bullet holes indicated that the bullet path was almost at right angles to the side of the head. The distribution and intensity of the blackening to the ear indicated that the shot had been fired from extremely close range, probably with the muzzle of the gun in contact with the head. A bullet was recovered, possibly homemade. Mr. Brooks, a firearms expert, stated that the recovered bullet bore rifling of a style made by a Smith & Wesson revolver. It was more likely to have been fired from a revolver than a pistol, according to the judge in the summing up. There were injuries which indicated a struggle, and we get this from Dr. West, the defense pathologist, who noted that Hardip described a struggle in which his father and the assailant had their arms around each other. He commented that there were injuries to the head of the deceased and both his arms, entirely consistent with his being involved in a struggle and with his having tried to protect himself. You will realize that on Hardip's description, the two men were face to face with one another, and the gunman, I suggest, if you think about it, must have had the gun in his right hand, having regard to the angle of the shot. This is important, we say, for three reasons. First, the admissions that Oliver later made make no mention of a struggle and do not account for the gun being held anywhere near the head of the victim. Secondly, Oliver, and I will have more to say about this later, is heavily left-handed. Not likely he would hold the gun in his right hand. Thirdly, and this is important having regard to the description that Samuels gave of the man Harvey having the gun in a pouch by his groin, the gunman obviously had in this short incident easy access to the gun. He either must have had it in his hand during the struggle or been able to have ready access to it at a moment's notice. Oliver's contraption of the string holster that he had to untie to get hold of the gun does not cut that mustard. I come now briefly to Mark Purchase and the recovery of the hat and his identification evidence. I will deal briefly with the identification evidence because the judge dealt with it very thoroughly and fairly in his summing up, and there is a full précis of it in our appeal argument. It is interesting that Mr. Purchase was the man, just how it happened, was the man who recovered the hat. To cut quite a long story short, he went with police to tour the area, and they went to Arrow Court, and there it was he who found the cap. That's why it was given to a police officer before these photographs were taken. But near to the area where the cap was found, there was a khaki jacket. And could we just look at that scene, please? We don't see it very clearly, but it is perhaps useful to the court to see where the khaki jacket was found. System is still recalcitrant. Well, I see. There it is. You can just about see it to the left by the wall. Thank you very much. It's described by Purchase as being a khaki jacket. That's just where it was found. That is part of Arrow's Court. You can see it's rather a narrow area. Thank you. Now, Mr. Purchase's identification, if I may, I'm here, we have a full summary of that at paragraph 59 and following of our appeal summary. He gave very generic descriptions of the physical appearance of the two men whom he'd seen coming out of the shop from the opposite side of the road, about 20 meters away, as was established a few moments ago. Each of them, he said, was about 5'10", medium build, and wearing dark clothing. So on that basis, they're both of similar height. And Oliver was 6'3" and of large build. At the identification parade, which was held about a month after the offence, where Oliver was at position 9, he did not identify anybody and said, "I think he's changed his appearance so much, and I just can't." But that evening, having thought about it, he told his girlfriend, Vanessa Fulks, he was sure that the gunman had been at position 9 in the parade. But he didn't tell the police that until a month later, on the 16th of January 1991, when he saw a DS Murray, Detective Sergeant Murray, and told him of his view that it was number 9 on the parade. Although in his statements he said that Murray had said nothing about the suspects, he claimed in evidence that on the 16th of January, he, Purchase, had said over and over again that it was number 9 and that Murray had confirmed that fact. A police officer confirming who the suspect was, in effect. When Murray gave evidence, he denied that he'd ever said anything to that effect prior to his statement of the 16th of January, because so to do would have been improper, as indeed it would have been. He might, on the occasion of the parade for the second man, that was Samuel, have inadvertently confirmed that Purchase had identified the subject. On the face of it, therefore, Purchase must have lied to the jury. And you'll have seen that the judge said that Mr. Purchase had said a number of things. Not the least of the discrepancies was the varying order in which he described the two men, about the order in which the two men had left the shop, about which he changed his mind not once but twice. The judge described the witness vividly as a somewhat excitable person who, at the time he had the opportunity of seeing faces, was trying to use his mobile phone. And you'll remember that Mr. Purchase was trying to call the emergency services, having heard the shot at the time when he saw the two men leaving the shop. And the judge stressed that Oliver was 6'3". 5 months had elapsed before the parade. He had on the evidence only 3 to 4 seconds to see the men, and the lighting conditions were difficult. The court had visited the site and had seen the site at night. And the judge commented to the jury that had the case depended on Purchase's evidence, he would have withdrawn it from them. So he was very far from being an impressive witness. Oliver was not picked out by 2 other witnesses. The most important, of course, was Hardip and a Mrs. Baker. Each of them picked out someone else. She claimed to have seen part of the incident, but I do not trouble your lordship further with her, because a police report claimed she'd become hostile to them, and they had some doubts about her reliability. I don't know whether those doubts were justified or not. It's important, I think, to bear in mind that Hoondle, thinking of the descriptions given by Mr. Hoondle Jr., Hoondle Sr., the unfortunate victim, was 5'9" tall, according to the pathologist, Dr. Rouse. So if a man of 6'3" had been tackling him and struggling with him feet away from his son, the son would surely have seen that and would have seen a man towering over his father. I hope that's not hyperbolic. Certainly much taller than his father. This identification begins to look, when analyzed in that way, very shaky. And indeed, the suggestion that Oliver could have been a person much smaller than the description suggests is very shaky. Another point on identification relates to Mr. Gager, paragraph 71 of our summary. Mr. Gager, as I mentioned to you before when we saw the plans, was driving along Clarence Road towards Mare Street, that is southwards towards South Hackney. He turned left into Arrow Court towards the service road. He saw two young black men literally sprinting along, as he put it, who ran past the offside of his car. They turned right into Clarence Road, heading towards Downs Park Road, as the statement says. Now, turning right, they would have been going towards Downs Road, where Samuel's father happened to live. The statement is plainly wrong. But I mentioned that in case my learned friend wants to take any point on it, and so that the court is aware of it. The case has always been put, and indeed Samuels was questioned on the basis that he ran past his father's house. So they went to Downs Road, not to Downs Park Road. But the important and interesting point about Gager is this. One of the two men tried to hide his face using a white plastic bag as they passed. One man was mid-20s, about 5'8" to 5'9" tall, medium build, wearing a tracksuit top. The other was of similar age, slimmer than the first, wearing a light-colored top, either a jacket or even a tracksuit top. There was no suggestion that one man was significantly taller than the other. And if he'd seen a man of the size of Oliver, 6'3", literally sprinting along, that, he would have thought, would have been something that he would have noted and mentioned. And the other point is that only a week or so before, when Carla sold him the hat, he was limping. So if he was that man sprinting, he must have made a pretty good recovery fairly quickly from whatever it was that caused him to limp. Forensic matters. None of the fingerprints found at the premises was identified as Oliver's. There were fragments of 4 black hairs and of 1 brown hair found in the baseball cap. The brown hair was not examined in detail. The 4 black fragments were different from hair samples taken from Oliver and Eric. In its first investigation, the Commission very helpfully made inquiries of the Forensic Science Service as to whether the hairs from the cap were suitable for DNA profiling or mitochondrial, I can never pronounce that word, profiling. They were not, and this was confirmed again by their recent inquiries. So obviously the inference is that at least one other person during the week that he'd had the cap had worn it. That in itself might not be of great consequence, except for the other matters I've mentioned, the nonsense of the admissions we shall have to look at, and the repeated exonerations. It then becomes of considerable significance. I just deal very briefly with publicity. In other words, Oliver's opportunities to hear about this from other people. Perhaps the main and most obvious source, potentially, of information about the robbery would have been Samuel's. I think the name is Samuel, actually, Eric Samuel, who was his friend and whom he undoubtedly saw within about 2 weeks or so of the robbery. There was extensive media coverage, and I can deal with the details of that if your lordships wish.
Just, I'm sorry to interrupt you, just help me if you would with
yes.
what you've just said. I thought you told us earlier that Samuel was in custody very shortly after this incident.
No, I think I had failed to mention to you, he'd been released on bail on the 13th of June, and he was on bail, obviously, at the time of the robbery. He failed to sign on for his bail the next day, and if my recollection serves me, I think he was rearrested in October.
Right, I think you might have said he was rearrested on the 24th of July.
I might well.
You did say that.
I had totally misread my note, and I stand corrected. I'm sorry. What's that? Well, he rearrested on the 24th of August. Yes. Anyway, it's common ground that he was free within the weeks after the robbery, and that they did meet. I say it's common ground, I assume it is, because Samuels described it in the interview he had with Linda Burridge in 2001. I should mention that Eric Samuels was signing on for his bail every night, and it's of some interest that he signed on the 20th of July at 19:26, 7:26 in the evening. I haven't made a note of the police station. I think it's Hackney. At 18:50, 6:50 on the 21st, and on the 22nd, the day of the robbery, at 6:10 at Hackney Police Station. So now the arrest and the interviews at Plaistow. We will have to look with some care at the Plaistow interview. Paragraph 81 of my summary. He was arrested at 30th of November 1990 at about 7 o'clock by Detective Sergeant Butters in company with 3 other officers, Hickson, Dobinson and Noel. Told he was under arrest for murder of a shopkeeper at G&H stores on July the 22nd, cautioned, alleged to have said, "I don't know nothing about the no shooting," told they would discuss that later and police would search his right flat. "All right," he is said to have said, "but I didn't shoot the man." On the way to the police station, he said, "You mean the Asian man that got shot?" Butters said, "Do I?" To which he replied, "I remember all about it from Crime Watch UK." He said that was the only murder he remembered from Crime Watch, and someone grassed me up. According to Hickson, as they went to the police car, Oliver was asked about his flatmate and whether he was a good mate. He said, "No, not really. I've only got one good mate, and he lives right over at Dalston." He was obviously referring, as we will see, to Eric and was saying he lived in Dalston. He was first taken to Plaistow Police Station, and the first custody record shows that on arrival he was processed with extraordinary speed. He arrived at 7:50 in the morning. He signed that he did not want a solicitor at 8:02. He did not request that anyone be informed of his arrest. A note at 8:02 authorized his detention and said, "Taken straight for interview," and no representations made. Even by the standards of those days, there could not have been any real attempt made to ascertain what his wishes were in relation to having a solicitor to assist him in a murder case. Butters and Dobinson conducted a tape-recorded interview which began at 8:10 a.m. He was cautioned. He was not told of his right to a solicitor or an appropriate adult. He was not shown any notes because the police had not at that stage made any, as we'll see. Can we now look at the interview, please? And can you give the reference, please? And I will be using the paper bundle. Yes, can you give the page? The beginning of the interview. Sorry?
Do you want it played?
No, I just want to look at the beginning of the interview, and then we will play 2 excerpts from it at a later stage.
My lords, my lady, this is the interview available at J2, pages 1 to 21. We'll be starting at page J2, 2.
Thank you. I will now use the page numbers of the transcript. It starts, of course, at page 1 to 2. You can see that he's not asked about a solicitor or an appropriate adult. You see, he says at page 2, halfway down, this may be marked, that he may have been in Lower Clapton Road. Over the page, he's asked about his mate in Dalston. Do you see that? Just before 2:39. What's his name? Derek, except because I don't know his second name. He describes him, older than me, about 20, 21, 22. Was he big? Think he's like the same size, a bit smaller than me, shorter than you? Yeah. Then he describes the man as having a gold tooth there, a gold tooth, and I believe that Eric Samuel did have a gold tooth, although I haven't got a photograph to demonstrate that. Whereabouts in Dalston he's asked, and then at 3:54, I don't know, I know it's used to be in a block of flats. That might be, I suppose, Bannister House, the mother's address. Do you know the roundabout in Lower Clapton Road? Been past it, and this is leading up to asking him whether he knows the supermarket. It's described on page 5. Again, he's asked at 5:10, do you know where he lives? I don't know. I know it was Dalston somewhere. I don't know. So Dalston figures again. Bottom of the page, we bumped into each other in the city, and when he said the city, he meant actually the West End. That's clear from a number of later references, not the City of London. Then page 6, he's asked towards the bottom about G&H General Store. I think I've been there. Next to a video shop, yeah, I've been in there. Over the page, I think it's marked for us. What did you get in there? Sweets, drinks, anything. And he would go mostly after working hours or before, so he knows the shop, according to this. Then he's shown at page 8 a picture of the hat. He nods to say that he owned a hat like that, and says at 8:59 he bought it in Stratford. 9:25, Butters wants to know on page 9, where's it now? I don't know. I think I might have given it to someone or dropped it. Bottom of the page, can you tell me where it is now? And I think it's here, at about this point, that we're going to start to hear several minutes of this interview and to hear the admission that he then makes. Is this 9:16?
9:03.
No, yes. 9:03.
My lords, my lady, this is we will play the audio from 9:02 to 13:56. It's at pages 9 to 13 of the transcript at the court's J2, 9 to 13.
Thank you very much. What's the time?
Sunday the 22nd. GH off license. Tell me what happened then.
What was shooting?
Yeah.
I think it was shooting. I was like this. I can't remember my mate's name. It's just like a main who I found totally.
What happened?
Thinking, no, I was in
Really?
the other engine shop. So I was like, looking and I didn't think he had a gun with him. You know, when he went up, I went to sit my hat, dropped on the floor.
What happened?
What?
Tell me what happened.
I think he tried to take what happened in the shop. I went in first. Then I looked and looked and there was no can.
Tell me the conversation that took place in the gym.
Can't remember that I was used talking to the Indian man.
What did he say to him?
Can't remember because I was in the right name, I was actually known for it.
What were you wearing? Tell me what happened again. Sunday. Sunday the 22nd. Well, tell me how.
And the suit, I was thinking my house was in the way.
Don't think, try very hard to remember what happened. It's very important. What did you meet him at?
Before, I didn't see it first and then came down.
Then where? Where did you meet him?
Leicester Square.
Where did you meet him in Leicester Square?
Did I get the job?
Yeah.
It's an arcade there.
Did you arrange to meet him?
I usually have to park in.
And then what happened?
I was around his house from Friday to like Sunday.
Tell me, I want you to tell me all about the shooting.
I didn't have to go right there.
Where did you get the gun?
I think it's in the boy or somewhere.
Where?
Don't know.
Can you describe the gun to me? Was it a big gun? What sort of colour was it? Dark brown? Tell me what happened.
Okay. Right, thank you very much. So can we go back, please, so that I can draw attention to a number of points on that excerpt that we've just heard? And can we go back to the point where Butters puts to him the mistaken version that he dropped it in the G&H off license? That is at page 10 of the transcript. Did you drop it at the shop on the Sunday the 22nd? Think I did. Dr. Beck will tell you that that is the kind of vague answer that the mentally challenged person might make when he was not sure of the position. But he goes on, I try to raise my voice, at G&H off license, yeah, tell me what happened there, what the shooting. I didn't do the shooting, it was both of us. I remember my mate's, can't remember my mate's name. But then if you go down towards the bottom, I was like with him, and then like he think he had the gun, and then I ran, except my hat dropped on the floor. So he seems by now to have accepted the false suggestion that the hat dropped on the floor in the shop, as we read it. But it hadn't. It had actually been thrown away at Arrows Court. Going on, at the top of the page, there is a detail at page 11 which is correct. If he was there, I went in first, then I looked around, then my mate came. And that is the sequence of events, it's fair to say, as described by Mr. Hoondle. But at the bottom of the page, an ultimate answer, last answer, I think my mate asked for some money. That was the first of two occasions when he said that. In fact, no money was asked for, and Hoondle did not hear any conversation, you will remember. Then he says over the page that he met his mate in Leicester Square, and perhaps a small point, towards the bottom of page 12, I stayed round his house from like Friday until Sunday. Well, I suppose it could well be that Samuels went to sign on for his bail by himself, but Oliver doesn't mention it. Not our main point by any means. So this is of interest and importance and concern over the page. Asked where he gets the gun, where his friend got the gun, I think he bought it off someone or he bought it himself, top of page 13. So his mate has acquired his own gun on this account. A little further down, past 1403, was it a big gun? No, a small handgun. Well, that is correct. What sort of color was it? Black. Not correct. It was a little silver, as you've heard. Dark black. Butters asks him a ridiculous question, what could dark black mean? And he acquiesces in that suggestion. Think it was dark black, something like that. Bottom of that page, what time did it happen? Think about between 5 and 7 o'clock, 6:30, something like that. Pausing there for a moment, it was alleged by the officers that after the tape had stopped, he corrected that and said, I think that the shop was shutting at the time. Although I suppose that could have been 5 or 7 o'clock. But the actual shutting time of the shop was about 10:30. But there he says between 5 and 7 o'clock, 6:30. Quite wrong. And after 1535, we find again the same inaccuracy about the money. Like he asked for some money. Butters says, did he ask for money or didn't he, halfway down the page? I can't remember what he said, because I was like the counter, I was like by the door. Facing which way? Facing the door which goes out into the street. Well, where is Baljinder Singh in all of this, we ask? Because you might have thought that it would be a very striking fact that even he would remember if he'd been there, that he'd struggled with somebody who he appears to have brought back into the shop, according to Hoondle's account, and had a mini fight with. But no reference to Baljinder at all. And then 1624, again we remember that Hoondle said that no words were exchanged. Mr. Campbell said, think he started arguing with the Asian bloke, then he shot him, like think he didn't give him money or something. Well, no words were said. I want then to go on briefly towards the end of the interview, where we'll see that he started to withdraw his admission, and we will play that short bit. But on page 17, please, towards the bottom, he describes Eric's house again as being in Dalston. He's asked what he did on the Saturday, describes the events of Saturday and Sunday, not of great interest to us now, page 18. Page 19, they went for a walk anywhere really, he says, just before 21:42. But then there is this. At just after 24 minutes, in the passage that we're going to play, he apparently withdraws his admission. Can we hear that and see the transcript, please?
My Lords, my Lady will be playing from 24:08 to 24:50, page 20 of the transcript at the court's J220.
Thank you very much.
Went to the shop, and the shopkeeper was shop. Why did you go to the shop?
Went to that shop. That's not shopkeeper. Very good.
Did you go there to borrow the shop? What did you go to?
Just get it out. Also.
You said earlier you were looking at. What were you looking at? Did you want to go to look?
Nothing else. That's just for that. After we go to the shop.
After you went to the shop. We'll discuss this in some detail later, actually.
So let us look at that, thank you very much, together. There's a word missed out. After 25:03, Campbell says, think that was the only shop I think he wanted to get, and I heard something. We've got the SO, wanted to get something. Did you go there to rob in the shop? No. What did you go there for? To get something, to buy something. You said earlier you were lookout, but I don't think he'd used those exact words, but that was a fair construction. Why were you looking out if you weren't going to rob it? No, I meant that's before, after we went into the shop. After you went into the shop. And then instead of pursuing that, Butters says, we'll discuss this later in some detail, so you can help me again. If we took you to Dalston, could you point out Derek's house to us? So there, I'm entitled to say, am I not, that he is apparently withdrawing his admission, or maybe, and unfortunately, Butters lost the opportunity to clarify that there and then. So much for the interview. Oh, over the page, I should mention, he says, page 21, can you point his house out to me? He says again, I think it's in a block of flats. I don't know, is it Dalston? I don't know the name of the route or anything. So Dalston figures again there. So I can just put that away. According to police, as I've mentioned before, he said unprompted at the end of the interview, I think the shop was shutting at the time. I think it was late. That was not recorded on the tape, according to the officers, but it certainly wasn't recorded on the tape. I want to say a word now, if I may please, about the problems of non-contemporaneous notes made collaboratively by officers who have interviewed or spoken to a man like Oliver, because there's quite a lot of that in this case. And I would like to say briefly this, and I hope it's fair and common sense. There were a very large number of off-record conversations in circumstances where no notes could be made. The notes were never made at the earliest opportunity and were never shown to Oliver at the earliest opportunity. Indeed, most of them were not shown to him at all. There was a tendency, both at the trial and on the appeal, to treat such notes as if they recorded the exact words that he had used. The problem is obvious on listening to any part of these tapes, that he spoke softly and sometimes very unclearly, and I am now raising my voice, sometimes very unclearly, and he mumbled. In regard to the arrest, the notes record events starting at 7 a.m. They were not made until 8:40, by which time two of the officers concerned in the arrest had heard him make admissions. There was an obvious risk of confirmation bias, the tendency to search for, interpret, favor, and recall information that confirms or supports prior beliefs. So the officers who believed he was guilty because of what they'd heard in the tape interview, that might affect their, honest account of what he'd said earlier. And it becomes more important in relation to D.S. Ellison, who makes a number of notes of off-record conversations, he being a man who believed very strongly that Oliver was not just there, but the gunman. So having said that, may I take you briefly to the car journey, where he tries but fails dismally to show the police Derek's address, his friend's address. At 10:15, Butters told him they were going to Hackney police station and said, on the way, this is page 92 of our note, I'd like you to show me where you stayed with Derek on the weekend of the shooting. He agreed to do so and said once again that it was in Dalston. But then at about 10:20, he said he thought his mate lived in Leytonstone and agreed to point out the address. He directed police to Angela's home that we've seen at 6 Phillibrook Road, Leytonstone, the one where Samuels had not been living since the 13th of June. 13th of July. He could not remember if his mate lived upstairs or downstairs. He'd lived at the flat since after the summer. He didn't know if his mate still had a gun. He might have thrown it away. Asked when he'd last seen the gun, he gave the cryptic reply, according to their notes, not since the man. I should say that a woman police officer, Noel, was trying to make a contemporaneous note in the car as they were driving along, not since the man. They then drove at Oliver's direction, and Oliver asked the police, tell me who you were talking to yesterday. When asked what he meant, he made no reply. He was asked, who have you told about this then? Of course, he hadn't been cautioned again during this. Alison, he said, from Kingston. Did you tell her all about the shooting? He replied, not all of it, according to the note. He then gave directions to a number of roads in Hackney, which PC Noel was unable to record, and en route to the police station, he directed police to Bannister House near Homerton Hospital, and then to Mandeville Street in Hackney. So he did, it looks as if he did actually take them to an address where Samuels might have been living in Dalston. So he probably did not show the police an address where he could have been staying with Samuels on the weekend of the robbery. Police and Oliver were completely at cross purposes, and if one were to look at the transcript of a later interview at Hackney, where he was asked why he had taken all officers to addresses in Dalston and Leyton, and he said, because they wanted to know where my friend used to live. And I'll be given the reference to that, please. We don't need to look at it.
You can find that at J2, page 130.
So it looks as if police and Oliver were totally at odds as to what he thought and they thought he was doing. We then come to Hackney Police Station and Mr. Ellison's introduction to Oliver, as he termed it. The custody record noted arrival at Hackney Police Station signing the record to confirm that he did not want a solicitor and he did not want anyone informed of his detention, all timed at 11:15. But then if we were to look at it, we would find that at 3:11 p.m., it was signed by Maria Marshall, who was from his solicitors, in two places, and she'd obviously arrived by then. How this change of mind came about is not recorded anywhere in the custody record. So, presumably, he had said to a police officer that he wanted a solicitor, or they had decided that he should have a solicitor, we don't know which, but there's no record of it in any official police document, although we will find a record in the defense documents, and I'll come to that in a moment. He was examined by Dr. Henry at 12:07. It was a fairly brief examination. He recorded he was not under any current medications. He had some stitches in his head as a child. That seems to be how he was referring to his brain injury. He appeared of limited intelligence. He was not proficient at reading or writing, capable of, and then a word is missed out, the reasons for his being interviewed. I certified he was fit to be detained in a police visit. The custody record suggests that the examination took about 13 minutes. By modern standards, it was very perfunctory, and Johnson commented in his 2003 report that the doctor did not appear to have assessed his fitness to be interviewed, and that these days, this was in 2003, this is something that medical examiners are far more involved with. The reference, I think, is M3 at 661. Yes, thank you. And the police report mentioned that it became apparent that he was perhaps mentally backward. And then at 12:20, Ellison went to introduce himself to Oliver. Perhaps I can properly say that in about 50 years of practice at the bar, I don't recollect a case where an officer did this, an officer who was going to interview a man on tape, going to introduce himself to that man, because, of course, as you will know from experience, the introductions are always done on tape. But that's what he said he did. According to Ellison, Oliver asked, "How did you find out about me? I mean, who grasped me?" He, Ellison, told him it was best not to talk about it now. Oliver said, "There's some girls, a couple of girls. I told them what I'd done in the murder, like, was it them?" Ellison again told him not to say any more. Oliver said, "I need to know how you found out like I done it." Ellison said, "It's a number of things. You said certain things to other people, obviously, but that's not the only reason we found out." Oliver asked, "Have you caught my mate?" Ellison then repeated that he should not say any more, and he was returned to the cell. Curiously, Mr. Ellison made two statements, each dated the 21st of December 1990. One makes reference to this introduction, the other does not. However, we can deduce some of what must have happened, or very likely happened, from a short note made by Maria Marshall of the firm of solicitors Mullinger Banks. And she recorded, can we just look at this, please? Well, maybe we don't need to look at it because I can read it to you. Yes, can you have the page reference anyway?
It's at CACD1, page 1884.
1 p.m., she recorded, telephone call from D.S. Ellison. Oliver had been arrested on suspicion of murder. Oliver was not prepared to make a statement without me being present. Well, how that squares with what Ellison had described in the introduction conversation is difficult to understand.
And the reference for that later quotation is CACD 1810.
Sorry, speaking for myself, I don't find it very user-friendly to give us one-page reference and then, before we can find it, deal with a different point about which we're retrospectively told another page reference. If anybody wants us to look at pages, of course we'll look at them. If you don't want to look at them, then please don't
Lord, I'm sorry.
don't tantalising page references as if you did.
I'm sorry, we don't mean to tantalise the court. We simply make what we think is an obvious and powerful point, that it is difficult, indeed impossible, to reconcile what Ellison recorded in his introduction with what he told Maria Marshall at 1 p.m. Oliver was not prepared to make a statement without me, that is Maria, being present. That is an obvious and worrying contradiction. And we say that the absence of proper records of significant events alleged by Mr. Ellison at Hackney is a very troubling feature of this case. The upshot was that 2 members of the firm of Mullinger Banks arrived. They decided that one, Jean Eldridge, would advise Oliver, and the other, Maria Marshall, would act as appropriate adult. And the interviews are summarized in our appeal argument at paragraphs 104 to 115. Time, please. Their substance is one of denial, punctuated with no comment, but with remarks showing that he had some knowledge of what happened. I want to highlight a few points. It would have been much better if Butters had continued to interview Oliver. He would surely have taken up the point that Oliver had appeared to withdraw his admission of having intended to rob the shop. Instead, Ellison had clearly been tasked to interview Oliver, and he was plainly determined to get a confession to Oliver's being the gunman. He apparently did not know that Oliver had made a confession to dropping the hat in the shop, which could not have happened. Moreover, Oliver was very reluctant, plainly, to tell the police about his problems of memory and comprehension, as we will see presently. And you will remember that in the report of Dr. Young, a conclusion was that that was something that Oliver was very reluctant to do, to own up to his problems of comprehension and expression. So the combination of Ellison's ignorance that Oliver had admitted to something which was physically impossible, his apparent ignorance that Oliver had wanted to withdraw his confession at the end of the Plastow interview, and Oliver's reluctance to tell people, strangers, about his problems, was a potent mix for injustice. The danger was that he'd be drawn by a man much cleverer than he, convinced that he was the gunman, into making a false admission. And again, it wasn't their fault. Neither of the solicitor's representatives, as they confessed in the interviews, knew very much about his problems. They made no interventions during the interviews at all. Give me the time. What's the time? I'm told that it's 1 o'clock. The clock doesn't work.
Yeah, the one behind you does, but that's not very helpful when you're facing
Sorry, what? I'm sorry. Ah, right. Well, I would, yes.
Right. Very good. Well, we'll adjourn then till 2.
Thank you.
You're clearly covering a lot of ground. Mr. Birnbaum, you made a prediction at the start of the morning as to how long you would be taking. Are you keeping up with that?
Frankly, no. The interruptions have not helped. I think I may have underestimated the time. I'm going to cut some of the things that I say and refer you to the relevant parts of our case summary. I am hopeful that Ms. Slowe will be on her feet at the end of the afternoon. And tomorrow I am proposing to take the expert evidence relatively shortly.
Right.
So we may make up some time in that way.
Very good. Thank you. 2 o'clock, please.
Lord, I continue my struggle with the acoustics in this court. I've asked my learned friend to give me a gentle prod if I do not keep my voice up. I'm trying to do better. I realise that I have forgotten to show you something that we regard as rather important, which is the photo fit that Hardip made of the man wearing the hat. And to remind you, he said that on the front, British Knight's cap on the front, trade name, I think in silver. I think the cap had checkered boxes as well. And if Miss Slowe would show us the cap, first of all.
You did show us this because it was on the Crime Watch.
Yes, that's right. But here, yes.
If you want us to see it again, then
yes, I want you to see the cap, and here is the cap, and you can see British to the left, Knights to the right, and then a sort of hatched area, what he seems to have described as checkered boxes as well, if you look at that. Mm-hmm. And our point is, looking very quickly at the photo fit, he's captured that pretty well. Mm. Not, of course, absolutely accurately, but well enough to suggest that he was right when he gave the impression that he'd had a very good and sustained look at the face of the man wearing that hat. Moving swiftly back then to the interviews conducted largely by Mr. Ellison and by Mr. Valden. The first one started, and here I'm at page para 104 of our appeal argument, when after the caution he was asked his name, he said, "My name is Oliver Campbell and I'm a witness." He didn't understand his true status as a suspect, even though by then he had had a private interview with his two solicitors' representatives. Nobody corrected him. The interview did not begin with Ellison putting a summary to him, or putting to him what he was supposed to have said in the introductory remarks. It is important, I think, to look at page 33 of the transcript of this, which is J2 30 to 33, if we can please, because I'm going to submit to you that Oliver very nearly disclosed his defense, as it ultimately became, that he was being badgered and bullied, and so he did not have an opportunity to really think about things and disclose the whole of what he could remember, as he might have done had he been given encouragement. So, can you get this on the screen for us, please? It's, sorry. Sorry? The Hackney interview, yes. Yes, it does. Yes. And yes, I'm just going to find it in my bundle to assist the learned friend. Sorry? The first Hackney interview.
It's at my lords and my ladies, J2, pages 22 to 45.
Yes. And I think Mr. Birnbaum said he wanted to go to page J233.
Yes. Yes, I'm sorry. I've not got my tackle into order over lunch. It's my fault. I'm sorry. I think I've lost a post-it note, and that is the source of the problem. Yes. Can we get it up on the screen? I'm so sorry. Yes, it's page 5 of the transcript. It's page 33 in the bundle of transcripts. That's why I mentioned 33. Starts at 32, in fact, where he said, he's told he, where are we there? What? Sorry, I can't quite see. Can we go to page 5? Starts at the bottom of page 4. He's asked about an item of clothing that was found, and he said, I know something about it because you told me this morning. This is to Ellison, who doesn't contradict him. What do you know about it? He says, I know it's been bought in the shop. Yeah, and you bought one similar to that? Right. Where did you buy it? In East London. This is towards the bottom of page 5. He paid £8.99 for it, £11.99 for it, he thinks. Then he says, in page 6, Campbell, halfway down the page, probably marked, that was on Crime Watch UK. You recognize the hat. I just told you, I said like it's on Crime Watch UK. Page 31, or 7, 2 numbers, I think. What happened to it? It got lost. I can't remember. You must be able to remember how a hat got lost. I have everything like this is. I'm running from the site and all that. How much money do you earn? Have you got a job? No, I'm unemployed. So he changes the subject there. Then Oliver asks if the interview can be stopped, and Ellison will not stop it, but eventually he gives up at page 9. When Oliver says, just over halfway down the page, carry on. Then he says at the bottom of the page, page 9, it looks like my one. It does look like yours, yes. And then this. Right, could you have worn that hat? I might have, because I wore something like that. What did you do with it? Don't remember. I think the last thing you said was that you last saw it in the city, yeah. Now, where are you talking about? Outside the Hippodrome. That, of course, is near Leicester Square. Right, you know the seminar? Yes. When was this? It was a Saturday. I can't remember what day it was. It was a Saturday. Well, if it was the day of the murder, that would have been a Sunday. But he's saying he last saw it outside the Hippodrome on a Saturday. What were you doing there, Ollie? Hanging around with my friends. Who's your friends? There's loads of them, because I can't remember all their names. Well, who was this friend, Ollie? There was loads. I said there was loads. Yes, because they don't usually tell me what their name is. What happened to your hat? I can't remember. Well, I know we established that you only get about £36 a week, don't you? He says, changing the subject. Yeah. And you pay £12 for a hat? Yeah. And you can remember wearing it outside the Hippodrome, outside there or somewhere around there. Yeah, but you say you can't remember what happened. No, it's not true, is it, Ollie? It is true. It isn't. How can that be right? How can you not remember that? What? How can you not remember that? You're forgetting it because you don't want to remember, I think. I'm sure on a Saturday. So what happened to the hat? I can't remember what happened to it, because I went somewhere else afterwards. Where was that? I don't know where it was. Page 12. So you don't remember where you went either. No, got a very convenient memory, haven't you? So someone more patient and knowing of his disabilities might have been able to ask him sympathetically, well, what happened? What do you remember? And the significance of it is that if there is any truth in the story that the hat was stolen from Oliver by the man who went on to commit the robbery, then it happened near the Hippodrome, near Leicester Square, which was where they all used to, forgive the colloquialism, hang out together. We will never know what he might have said had he been more sympathetically interviewed. I put that away from the time being because I'm not now going to refer you to the transcript again until we get to the crucial interview. And I want really to do this by way of summary, and I will refer
Just before
you...
you move on, and just before we leave the subject of the hat.
Yes.
On the subject of hats generally, there's a gentleman in the public gallery wearing a hat. Please take it off. Thank you.
Thank you, my lord.
And I repeat what I said earlier about mobile phones. I'm not accustomed to having to rebuke the public gallery even once, let alone twice. Yes.
At paragraph 106 in our summary, we point out that Ellison said to him, "Well, I think this morning you agreed you might have dropped it near to the scene of the shooting." So Ellison seems to have been under the impression that Oliver had admitted what would have been the truth, that he had dropped it near to the scene of the shooting. He might have had a different view of Oliver had he realized that Oliver had made a wrong admission to having dropped it in the shop. One can see how the possibilities for injustice at the hands of a very clever detective who was sure he'd got his man were mounting up. Now, I want at this stage to rehearse what I understand to be the police evidence against Oliver. We have a number of sources for this, and the importance of it is that we say that they were lying when Ellison chiefly and Vowden to some extent told him about all these witnesses they had against him. We have 5 reasons for thinking that they had nothing beyond Carla, the girl who had sold the hat. First of all, because Graham Bowl, Queen's Counsel, told the judge on the application for severance, perhaps the one concrete piece of evidence police had to go on immediately after this offence was the discarded clothing, in particular the British Knight's hat, which led to Jubilee Sports in Stratford and the identification of Campbell by the girl Carla. And that is Y1102, if I can understand the references. Secondly, in a report prior to the appeal, 01-39, Ellison wrote this: "The names Ollie and Eric were names suggested by informants. This was low-grade intelligence which was never developed beyond the evidence which eventually formed our case." So there was no suggestion there that any witness had implicated Oliver beyond some low-level intelligence that was never developed. Thirdly, there is our analysis of the witness statements, both used and unused. I confess that we do not have them all, but judging from the names and occupations of those we don't have, they were probably largely continuity statements. There is nothing in that body of evidence beyond the statements of Carla Hills to implicate Oliver in any way at all. Fourthly, during the interviews, Oliver was repeatedly fobbed off when he asked who the witnesses were. And fifthly, there is the simple fact that no one other than Carla was called to give evidence against him. So we say we are on very good ground in suggesting that whenever the police suggested, as they frequently did, that they had lots of witnesses against him, they were lying. They even said they had fingerprints. They did have fingerprints, but they didn't have fingerprints of Oliver. Now, I'm not going to go through all of this, but you can read the detail in the appeal argument in paragraphs 153 to 186, which indicate not only that they told that lie, but that Oliver was humiliated, frequently told by Ellison that his body language betrayed guilt, and frequently given strong indications that either it was a deliberate or an accident. And it was even suggested at one point by Ellison that perhaps the person who fired the shot didn't realize that the gun was loaded, something for which there was no evidence at all. He was being dangled with the temptation to admit that it was an accident. And on the question of accident, the relevant passages are summarized and all of the links are given at our paragraphs 452 to 3. It is a disgraceful series of interviews of a kind that no police officer today would dream of conducting. But in those days, interviews were rather tough because the police were tending to follow what was called in America the Reed technique. You will have read about that in the recent report of Johnson, where officers were told to emphasize the strength of the evidence and to offer, a paraphrase, the defendant a way out, an easy way that would not be so serious. If you admit X rather than Y, it'll be better. But I have to say that they were never told that they should lie. I'm just looking at my note to see how we can curtail things. That was the spirit of the interviews on the first day, the 30th of November at Hackney. Save that, the final interview that day, it was the 10th tape, he'd had a very long day, was in the presence of Mr. Mullinger, who was having none of it. And he criticized the officer for playing staring games and told him he was being unfair and frequently advised Oliver to make no comment, which he did. That interview was in the presence of a social worker, Miss Yeomans. It ended at 5:56, and Miss Yeomans had to leave. And Ellison said on the tape that there would not be another interview unless they could find another social worker. Quite fairly, you would have thought. And Mullinger left the police station shortly after 6:45 or 6:50 p.m., according to a statement that he made, 03126, but you'll see it set out there in our appeal argument. And he thought that the arrangement was that he would be telephoned by Ellison if he found another social worker and there was going to be, therefore, another interview. But no phone call came through. Once again, Ellison has off-record and unrecorded access and untape recorded access to Oliver. Can we look at the custody record, which shows that I mentioned this at paragraph 120 of my summary, CACD 1, 1800. This is, sorry? What? Yes. Yes. Can you look at it on your laptops, please? I'm told that will be easier. I don't know if that's right.
It's helpful if you direct us as you're doing
my lords, my ladies, it's at page CACD 1, 1800. At paragraph 120, we reference the custody record, and that there is a hyperlink there.
I think actually it's our summary, it's our printout of the summary. It's our typescript. Oh, right, okay. Right. 1930, D.S. Ellison to cell to inform subject that stepmother has arrived. Subject states he wishes to see her. 1933, Mrs. Jackson attends custody suite. Prisoner out of cell for consultation in tape room. That is with Mrs. Jackson. Very unusually, one might think. The foster mother of the suspect coming to see him would never usually be allowed to see him privately while he was still being interviewed. 8 o'clock, return to cell. 8:27, Mrs. Jackson attends custody suite. She is now acting as appropriate adult. She has had care of Oliver since he was 16, therefore aware of his problems, Social worker has gone off duty and therefore cannot attend. Fully explained to her responsibilities as an appropriate adult, she states she understands that. I'm willing for this interview to be conducted without a solicitor, signed by Mrs. Jackson. 8:32, subject out of cell, I'm happy to be interviewed without a solicitor, signed by Oliver and Mrs. Jackson. Ellison's statement, which is I-54, but we need not look at it, gives a quite different account. He makes no reference at all to having visited the cells at 7:30, 1930, but he did describe a crucial visit he made to Oliver and Mrs. Jackson at 1955, which is not mentioned at all in the custody record. So we know of two visits he apparently made. One is in his note and not in the custody record, and the other is vice versa, in the custody record and not in his note. According to his account of the visit at 1955, which is 1800 to 1801, I believe.
We're at paragraph 122 of our appellant's argument.
Yes, thank you. It's also in the numbers that I gave, but thank you so much. That's quite right. Later, Jean Jackson visited Campbell. At 17:55, he entered the interview room and asked if they'd had enough time together, and she said they had. He explained the requirement for an appropriate adult, and Mrs. Jackson agreed to accept the responsibility. Pausing there, that must have taken just a few moments on his account. Oliver said, I'd like her to stay. She asked if the position was serious. He told her that it was serious. Oliver had made some admissions, had sometimes made no answer, and had sometimes chosen to speak. He continued in his statement, I said that if Oliver was convicted, it would probably be for murder. This is in Mrs. Jackson's presence. Campbell asked if he'd go to a psychiatric hospital. He named it. I said I couldn't say what would happen. Mrs. Jackson asked if I thought he was guilty. I said, I really believe he shot the man. I don't think it was murder. Pausing there, in the context of the multiple encouragements to him to admit an accident, that could be said to be a strong inducement. I will come back to that point when I make my legal submissions. As the new appropriate adult, I explained Oliver's rights to her, and both declined a solicitor. We don't know what he said. Probably not very much. Maybe, do you want a solicitor? No. Oliver said, okay, no. Could be as little as that. He was aware that he had been represented in prior interviews. Campbell said, I want to tell the truth. I stopped him talking and took him back to the cell. En route, he said, and then note this, something inside me is wanting me to tell the truth. It's like a door opening inside me. I don't want to lie. I shot the Asian man. Those four rather striking phrases. I told him not to speak, and I left him in his cell. That phraseology, the court might think, is coherent and even rather eloquent. And after we hear extracts from the next interview, I will address you on the unlikelihood that Oliver could have been so articulate. So a number of points. First, what did Ellison say to Oliver on the visit at 1930, which isn't in his notes? Did Oliver really want to see her? Because we will look at defense records presently which show that that was the last thing he wanted. Or if he didn't want to see her, was he too shy and overawed to make that clear? Another possibility. Secondly, it's plain that Ellison was running the show. He was making visits to the detainee without telling the custody officer, viz. the visit at 1955. He was the one who arranged for Mrs. Jackson to be the appropriate adult, It should have been an independent custody officer who was independent of the investigation and who had no conceivable axe to grind. This is not just a technicality, it's a protection for the suspect, as you will appreciate. Here, Ellison, we say, and I don't think this is disputed, clearly wanted to hold an interview in the absence of Mullinger, and he needed an appropriate adult in order that the custody officer would allow him to do that. Because no custody officer would allow this man to be interviewed again without an appropriate adult, which he'd had throughout at Hackney. And thirdly, I will invite you, when you consider this case, to consider the statement of Mrs. Jackson, which is at I-65. And the point that I make is that when you read that statement, which was made to the police on the 2nd of December, the day after, one of two things will strike one. Either it's difficult to believe that Ellison said in her presence, I really believe it's murder, etc. Or if he did say that, and perhaps he did, she failed to understand the seriousness of the situation. But I don't take you to the statement now. I invite you to read it when you consider the case. So now we come to the substance of the interview. And what I'm going to do is to take you first to the transcript of the first few pages, and then, as before, we will play the central portion, and then I will comment on that portion. And the point that I'm going to ask you to have in mind is this possibility, that Oliver had plainly by then decided that his least bad option was to admit that it had all been an accident. And our suggestion is he thought he could get away with doing that the police would accept that and he could then go. But unfortunately for him, and perhaps fortunately for justice, Ellison couldn't leave it at that. He had to ask questions, had to ask detailed questions about what had happened. And since Oliver hadn't been there, all he could do was to make things up. And his account became increasingly divorced from the facts as we know them, increasingly inconsistent, and increasingly absurd. That is the thought that I invite you to have in mind.
Well,
yes.
What were the appellant's instructions about this?
I'm going to come to that, and an important feature of our case is that Oliver made a complete mess of what he almost wholly failed to come up to proof on vital aspects, including the way that the police had treated him. So if you will bear with me, I will come to that a little later. First of all, I want to look at what he actually said. But we do know what his instructions are, and we have them in laborious detail in a separate volume of the defense papers.
Right.
So, can I now take you to the start of the Jackson interview, if I can just do a little bit of housekeeping here. Yes, Miss Slowe points out that I've got the appropriate file behind me where I must have put it a few moments ago. I have to say that this hearing would descend into chaos very rapidly without her.
So, my lords, my lady, have the transcript to hand. It's at J2, pages 162 to 177.
Thank you. Right. So I'm going to begin at the very first page, and you can see it begins with the normal formalities, names, addresses, and so forth. Just an interesting point about Mrs. Jackson's position. On the second page, page 2, Mrs. Jackson is describing her knowledge of Oliver, Right, says Ellison about 10 lines down, as I understand it, you're willing to act as an appropriate adult, yes. The custody officer before we came in explained what was involved in that, and her answer is, spelled H-double-M. Doesn't encourage confidence that she did have any very clear understanding of what her responsibility was. But be that as it may, it's then established that she's the JP. She's still learning, she says at the bottom of the page. Then Ellison asks, top of page 3, now up until now, well, when I spoke to you yesterday, there was a solicitor present. Are you willing to be interviewed now without that solicitor? Rather curious way of putting it. And Oliver simply says yes. Can you tell me why you've made that decision? Because I want to say the truth now, what happened. Okay, Oliver, and what have you been advised to do up until now? Not to say nothing. Okay, but now you want to speak, is that right? Yes. Okay, now he's told us he wants to tell the truth under those circumstances. Are you quite happy that we carry on now? Says Mrs. Jackson to that very leading question. Right, what is it you want to tell me about what happened in the shooting? Okay, what did happen? I meant not what happened or why I took in it, if you understand what I mean. Yes, I do understand. Like my friend, I said in like what I said inside, I said, sorry, Ollie, could you keep your voice? Sorry, I mean I pulled the trigger. I was like in the front of the robbery, like my friend, except I don't know where he is now. I don't know if he's still. All right, don't worry about your friend. Like I pulled the trigger by accident. Sorry, could you say that again? I said I pulled the gun. I was the one like that pulled the gun on him and like shot him. You were, yeah? Why did you do that? It was by accident. Okay, why are you telling me this now? Inaudible. You know, just explain why it is that you're saying this. Something since Friday has been telling me not to say anything. But why are you saying this now? Don't know. Well, can't explain what's prompted you to say this thing that you call the truth. No, can't say anything else. Okay, well, there's a number of things because of what you said that I've got to try and clarify, okay? You said now that you were the man that pulled the trigger and it was an accident. How did you get hold of the gun? Where did the gun come from? I hired it from someone, like I hired, you know what I mean, someone gave it to me, and I said I'd give it back to them when I finished with it. Okay, you said the word hire, you used the word hired. No, I mean I hired it like a shop, not a shop. I meant I hired it from like someone and like they've got it back. Okay, have they got it back now? Yeah. Did you give it to them? What, the gun? Yeah. What, the first? What, before I used it? No, obviously you didn't give it back. Did you hire the gun more than once? No. Right. So can you describe the gun to me? Can't remember what. I know it's like a black gun. I don't know if it's like small or bigger. So again, it's a black gun. You don't. Where did the ammunition come from, or the bullets? From the same place. Where's the place, he asks, page 6? Don't remember, this was a long time ago. Well, I think it may be you don't want to tell me, which is okay. What area of London is it? Can't remember what area of London. You can't remember. What did it cost you money to hire this gun? Not a lot. Remember how much? What, roughly? About, I think it was 30 or more, I can't remember. Say that, £30, I know it was like, something like that. Says Campbell. Why did you want to hire a gun? I don't know. You don't know. What did you intend to do with it, Ollie? To muck about with it. To muck about with it? See, it went off in the wrong place at the wrong time. Did it? Okay, did it? Did you? Let's talk about that Sunday night, the shooting. Okay, where did you meet your friend? Down by near the shop, not near the shop, I meant about a couple of minutes from the shop. Says Ellison. We went in there like we had, like a dare, who's going to be the first one to get the most money? You had a bet. Yeah, who can get the most money and all that. That's a strange arrangement, says Ellison. What was the story behind that? What? Well, explain this. How did you come to be betting on who would get the most money? No, it was like my idea. Your idea? And how did you intend to get this money? Well, I didn't know because I thought I'd left all the ammunition out of it, except there was still one in there. So he's adopting the story suggested to him by Ellison earlier, that maybe the shooter didn't know that the gun was loaded. Sorry? Yes, and now I think we need to start playing the tape.
My lords, my lady, will be playing from 8 minutes 53 seconds to 16 minutes 44 seconds.
Before we do that, may I just invite you to turn on a couple of pages to page 9, and you will hear questions asked by Ellison, and you will hear the note of incredulity in his voice when he's asking Oliver, for example, about how long he'd hired the gun for. Thank you, Ms. Slowe. It's okay.
When did you check whether the gun was loaded? Okay. You went into the shop and you asked one of those men the name. That one that you had a gun out at that time. Right, you then go to your right hand and it becomes near your, underneath your left arm. Well, I'm asking you, is that how it was? Okay. How did you keep it underneath your left arm? I see. So where was the string from? I understand. Right. Is that, why did you have it in the arsenal? Okay. So, you didn't have the gun out when you asked for the name. When did the gun out? Where did you hold the gun? What did you do with oh, which hand were you holding the gun? You didn't say it was your right hand. Where did the struggle start? Why did you panic? Did you want to hear it? After Tuesday, what did you say?
I think we can end it there because this is where Mrs. Jackson wishes to go to the loo, as you see at page 15 of the transcript. Thank you very much. So I want to go back to where we started, if I may, in the transcript, in that excerpt, and unpick some of this and see whether it makes sense on any basis. I'm reminded to speak up. I will try to obey my instructions. Page 6, please. Ten lines from the bottom. Why did you want to hire a gun? I can't, I don't know, to muck about with it, to muck about with it. And he's asked, where did you meet your friend? Then, as I've said, the next page, he adopts the suggestion that Ellison had made to him before, that he didn't know it was loaded. Then we go swiftly over to page 8, where significantly, and perhaps plausibly, because he was heavily left-handed, he's motioning, pulling the trigger in the left hand. Ellison is having to help him and us understand what he was indicating there, because at the bottom of the page, Ellison says, I think you're indicating with your fingers the barrel. Well, that may have been Ellison's assumption, but we don't know because we can't see what he indicated. But he is giving some kind of purported impression of the mechanism of the gun to load and unload it, this black gun that he remembered. But then he talks about how long he'd had the gun. And this is where it really starts to unravel, because at the bottom of page 9, how long before the actual shooting had you hired the gun? A couple of weeks. And Ellison says disbelievingly, a couple of weeks or a couple of months, says Oliver. Now, this is very important because Oliver has misread the cue. Ellison, as an experienced detective, does not believe that anyone would hire a gun to Oliver for a couple of weeks. It would be much shorter. But Oliver thinks that he's not said long enough, so he says, or a couple of months. And this is our first clear clue that he's making it up as he goes along. Then it says, or a couple of months, I had to have practice on it. And again, incredulously, you practiced with it, says Ellison, not surprisingly not believing it. Where did you practice with it? In the fields. Whereabouts? Over the page, anywhere. And then he's asked about bullets. One's entitled to question why he would need to practice if all that the gun was required for, or indeed why he would need any bullets, if all that the gun was required for was to put pressure on a shopkeeper to hand over some money or goods. But that is what he said. Then he talks about where he kept it. Right, where did you keep the gun? Halfway down the page. Whereabouts? In a field. Where? Can't remember the field. I know it was somewhere near. My friend showed me where to put it, and like I go back there when I want it, I see, or was it the woods? I can't remember what woods it was. So the field becomes the woods. You can't remember which it was. Are you going to tell us who your friend is? No, because he didn't give his name, because I met him down in the city. Well, Eric, or Derek, or whatever he called him, must have given him his name at some point. And then over the page, he's asked about this rather outlandish bet. Then we get to conversation again in the shop, because halfway down the page, then what happened, that's what I did. I went into the shop and I said to the Asian bloke, or someone in the shop, I said, hand over the money, which according to Hardip didn't happen. Who were you speaking to when you said that? What, the money? I can't remember. I know it was someone behind the till. That would be Hardip. Now, Ellison obviously knows that Hardip was behind the till and that Hardip wasn't the man who was shot. So very reasonably, he asked, there was someone behind the till, but who did you say those words to? Expecting that Oliver would say, to the man I shot. But he doesn't. It's something like that. I don't know if it's the Asian bloke's dad or someone like that. Asian bloke's dad or he was. And then Bowden knocks over the box. Then over the page we get leaving the gun and checking it. Ellison says that it was a bet, a daredevil thing at the top of the page. That was like before we went in and that. All right, when did you check whether the gun was loaded? I checked before I left in the forest. Before you left, I left the place where I hid it. The forest. Yeah, it was the forest or some. Right, and you thought it was unloaded then. Okay, you went into this shop and you asked one of the Asian men for money. He says, perhaps agreeing, but we know he didn't. Did you have the gun out at that time? Not a surprising question, of course. No, I had my hand inside like there. Right, you're indicating with your right hand. So now he's got the gun in his right hand, according to this development of the story. That the gun was near your, Ellison, underneath your left arm. I suppose that Oliver must have been indicating underneath your left arm for Ellison to have said that. In his right, he's got it in his right hand, but the gun was underneath his left arm. Yeah, it was underneath my left arm. I'm asking you how it was. Okay, did you keep it there underneath your left arm? I tied it with a piece of string. I see. So where was the string tied? I meant the string was tied like there was two pieces. One, it was like tied around it, so I had to untie it before I took it out. I understand, right? Is that how? Why did you carry the gun in that way? That's the only way I thought it would be comfortable. Okay, so didn't you have the gun out when you asked for the money? No. When did the gun come out? When I got in, I lost my temper yeah? And then I pulled it out and I said, watch this to my mate. And then I think, like Squabble, or he stuttered or panicking. So he's talking to his mate. Come back to that in a moment. When did you point the gun? I can't remember when he was like crouching, going down on his knees, or just going. Yeah, why was he going down on his knees? No, I meant not going down on his knees. He was trying to move out of the way. I see. Which hand were you holding the gun in? This hand, you're indicating with your right hand. Why did the struggle start? Panicked too much. Why? Did the man say anything to you? Not really, no. Can't remember what he said, you know. I think he did say something, except I can't remember what he said. After the shooting, what did your friend say to you? Not a lot. I just told him there. He told me, meet me later on. What did he say to you? Can't remember what he said. Was he surprised? I think he was. Yeah, why do you think he was surprised? Well, I thought I wouldn't do it, but I said I was going to do it. Apparently some conversation with the friend. Well, now let's just go back over those last two vital pages. And first of all, about the string holster story. We say that it is virtually inconceivable that anyone would think of doing this, and it's very difficult to imagine that anyone, no matter how dexterous, imagine a person virtually ambidextrous, and therefore not having a stronger hand or arm, would be capable of holding the gun and two pieces of string and somehow making a holster or container with it out of those pieces of string, unaided by anybody else. But assuming that it is possible for someone to do that, we ask rhetorically, how was it possible for Oliver to do that when his left hand was by far his stronger hand, as all the expert evidence tells us? And then there is the nonsense of having to untie the pieces of string to get the gun out, which would have been seen, as I said before, by Hardip, not to mention that it would have given Mr. Baldev Hoondle an opportunity to perhaps to get away. And what has become of the string? And you see why before I was stressing that on Hardip's description, the man who did this dreadful deed must have had ready and immediate access to the gun. Well, Oliver didn't. If he did what he's describing here, it plainly is an invention by him. Then on that same page, watch this. Well, there was no conversation according to Hardip. Down on his knees, which he then seems to think better of, but that doesn't seem to have happened either. It doesn't square with Hardip's description at all, and it doesn't accord with common sense. And then, of course, at page 14, he changes his mind about going down on his knees. And then the passage at the very end of his friend, well, he thought I wouldn't do it, but I said I was going to do it. If that's a reference to something that he said in the shop to his friend, well, there was no conversation between the two, quite clearly, the two robbers, the two would-be robbers. So we say that this is really a tissue of nonsense. And insofar as we can check it against the known facts, the facts that Hardip recounts, it's wrong. But even if we didn't have Hardip, we would have every reason to think that it was an invention by someone who hadn't been there. And then, of course, at page 15, the unfortunate Mrs. Jackson is sick. And just pausing there for one moment, we are very sympathetic, as I'm sure everyone in court will be, to Mrs. Jackson. But the fact that she was sick shows that she simply was not able to fulfill her responsibility as an appropriate adult. She couldn't take it. Not a criticism of her. So I just want to do my necessary housekeeping and put this away. An interesting point was made by an expert consulted at the trial by the defense, Roger Thorpe. And we don't see from the summing up that Mr. Thorpe's evidence was called or read at the trial, but it was so helpful to Oliver that it would be strange if it hadn't been called. However, whether called or not, it is summarized at page 148 of our appeal argument, CACD 1, 1807. I think I'm beginning to get the hang of this a little. So Roger Thorpe said, and I quote, I'll read this slowly because one needs to think about it. Campbell's garbled description of the weapon strongly suggests that he is referring to a swing-out cylinder revolver rather than any other form of pistol. His description in the writer's opinion could have been derived from revolvers seen, for example, in films and television. It is unlikely that a single cartridge could be left in a revolver which was thought to be empty and then accidentally discharged by pulling the trigger. If a live cartridge were indeed present, in order for it to be hidden from obvious view, it would have to be in line with the barrel. Under those circumstances, when the trigger was pulled, the cylinder would rotate to the next and empty chamber before the hammer fell. The hammer would consequently fall into an empty chamber and no bullet would be discharged. So I hope that that is clear. If one looked down the barrel and thought that it was empty, that would be because there was a bullet in line with the barrel, but it would then, once you pulled the trigger, the mechanism would move the bullet on, and there would then be still an empty revolver, as you had thought. I put that rather clumsily, but I think you will understand the point.
Well,
so
this evidence wasn't adduced.
I'm sorry?
This evidence wasn't adduced.
Well, what I'm saying
unless
is,
it was in the form of
I think, and I won't go into this, that the list of witnesses is not completely accurate. The judge didn't mention it. The defense clearly prepared their case very carefully, and unless for some reason counsel had simply missed it, which is always a possibility, one can miss something, they would have no reason not to adduce this, is all I'm saying. One can't see a tactical reason why they would not have produced it. But maybe it was an understandable error and it wasn't produced. But we have it, and it is significant. I think your Lordship sees my point. Moving on, there's another interesting point here about the lights and the siren. There was one important matter that Oliver never mentioned, which he might have been expected to remember if he'd been at the scene. Before the shot was fired, Hardip activated the alarm. This triggered a light flashing outside the shop and a loud siren sounding both inside and outside the shop. There's no mention of this at all in any admission by Oliver. And it's worth noting that one theory advanced at the trial by Mr. Harrington, who was Samuels's counsel, was that the raising of the alarm caused him to panic and use the gun. The gun mentioned, the judge referred to this at the summing up, page 21B to E, Y1. I now want to jump ahead to August of 2002. On the 7th of August of that year, Mr. Maddox wrote to Dr. Legg, a neurologist who had examined Oliver in 1991, about his handedness, posing some questions and sending him parts of the Jackson interview. And in brief, Dr. Legg concluded that it would have been impossible for Oliver to have tied 2 pieces of string under his left arm because of his impaired right-hand function. He continued, I think the prestidigitation required to undo a knot in the piece of string holding up a gun so that it did not fall would be quite beyond him. So he could not physically have managed it in the way that he described. Of course, no one in 1990 to 91 could have had foreknowledge of a report that Legg did not prepare until 2002. But I think we are entitled to say that it is astonishing that no one seems to have questioned the veracity of this account, either as far as we can judge at the trial or on the appeal which took place in 1994. It seems to have been simply overlooked. I go back then to the last words that Ellison had attributed to Oliver before he reached the cell. Having heard his stumbling and semi-coherent words on the tape, could he really have said anything as eloquent as this? Something inside me is wanting to tell the truth. It's like a door opening inside me. I don't want to lie. I shot the Asian man. I leave that to your lordships, to the court's, good judgment. Later events at the police station I can take briefly. The next day, Ellison and Valden sought to interview Oliver again at 11 minutes past 10. On this occasion, both he and Mrs. Jackson said they wanted a solicitor. Mullinger Banks were not contacted at all until after this interview, but they were contacted and they came to the police station. There were 2 short interviews in the presence of Mullinger and Mrs. Yeomans. In the first, at 14:24, Mullinger protested about what had happened and advised Oliver to answer no questions. In the second, Ellison sought to show him a number of notes. It wasn't clear what they were. Mullinger said that he would advise Oliver not to sign any of them. However, we must consider a note that Mrs. Eldridge, who accompanied Mr. Mullinger, made that day. And what appears to have happened, if I've understood this aright, is that there was quite a crisis air about the defense lawyers that day, because they were trying to do 2 things. They were trying to protest per Mullinger about what had happened. And there was a discussion about whether the duty solicitor should be called. And then Mrs. Eldridge was trying to find out Oliver's account and also speak, I think, to Mrs. Jackson. And it seems that Mr. Mullinger was involved in various aspects of that. We have pulled out the times on the custody record in a way that I hope is helpful. And I want, first of all, to refer you to those times so that you can fit things into the general picture. It's CACD 1, 1956 to 1957, which is an extract from our further submissions as amended. CACD 1, 1956 to 1957. This is an abstract which we tried to make from the custody record, which is a little bit difficult to read at times. Have your lordships got that?
Not yet.
Thank you. Thank you.
Yep. Yes, I have. Just about to.
Right, we're all there.
Sorry, my lord?
We're all there.
Thank you. So, 10:40, Mullinger Banks were called. 11:05, they call back, will attend in 1 hour. 10:07, Mullinger attends, wishes to complain about interview. 12:14, requests private consultation with Campbell in co with Mrs. Eldridge, solicitor's assistant, duty solicitor called. 12:15, reference to interview room and GDI called. I haven't understood that, but I simply mentioned that. Then the next one is, when it says 12 o'clock, that should say 12:20. Duty solicitor Marcus Barnett calls and speak to Mullinger. 12:24, consultation continues. 12:33, Mullinger out from consultation to speak to Inspector Hayhoe. 12:47, consultation continues. So against that background, we can begin to understand the context in which Mrs. Eldridge made a note. And I want, first of all, to refer to the way that she noted it later in a typescript, but then we'll go back to the original note. So this is at CACD 1-1843, Mrs. Eldridge's written typed attendance note for the 2nd of December, 1990. 1:20 p.m. Do your lordships have this? Does the court have this? I'm sorry.
Not yet. Page 1843, did you say?
1843.
1843, paragraph 301 of our appellant's argument. There's a link there to the statement at M369, and it's also copied at that paragraph.
Thank you very much.
Thank you.
1:20 p.m. During the interview with Oliver alone, he stated that he told the police everything as something inside made him tell. He couldn't remember where the man he was with lived or remember what he took. He thinks he slipped and pulled the trigger of the gun and thought the gun was empty. It was not clear whether Oliver was making a confession or telling a story as if in a television program. This needs to be investigated much further. Now we need to look at the original note, which is slightly different. Can I just hold up the original note? And it's here. I've got it if you wish to see it. I just want to point out that at the top, and I'll come to the significance of this later, it says, Richard Clark told police I had hacked. Let us now look at the note which is to be found, and again I'll be helped, at 03-26. I've told the officers £30.
Sorry, you'll just have to pause.
I'm sorry.
Speaking for myself, I don't know what page you're wanting us to look at.
Yes, I'm asking you to look at a page of the manuscript note that I've just held up.
Yes.
The facsimile of the, which is a photocopy of that, and it should be at 03-26.
Well, that's the typed copy.
Ah,
That's the attendance. That's the typed attendance note, Michael. That's the typed attendance
Yes.
note.
The previous item is 3.
I think it's
Forgive
the
me.
preceding item.
yes, yes, I understand. We've got the wrong one.
Right. Thank you.
Are you there?
I think it's
Yes.
page, letter 03, page 6, by the look of it.
Okay, thank you.
Assuming that's what you just held up.
Yes, I was looking at the...
Yes.
My note was right, I was looking at the wrong part of it, which doesn't help.
Yep.
I've told the officers, £30, I've told them about gun. Richard came with foster mum, that's Richard, his flatmate. Why did you say it? Something inside me, I gave gun back. I can't remember where man lives. Then reference to Mr. O'Callaghan, the duty solicitor. Trousers, I know about them. It's the top. We took some money or something. I think I slipped and pulled the trigger. I thought it was empty. So that is perhaps a slightly fuller account than there is
I'm sorry, I'm just not
page?
finding this.
I'm sorry?
You held up what we have electronically at 036. But what you've just read out, I don't think comes from that page.
It might be a later page within that document.
Yes, it is. I think it's page 12. I'll just
Page
check.
12, all right.
Just a moment. I'm so sorry.
Well, these are notes of interview.
No, these are her notes. These are her notes of the entirety of her attendances on those 2 or 3 days on behalf of Oliver. And this is her note
0318.
of
And so
what he said to her.
Page 12 in the top
Yes.
right-hand corner.
It is.
So it's
No, it's not. Just 1 minute. So
R0318.
sorry. It's page 14, I think. It's page 14, yes. I've told the officer £30. I've told them about gun. Do you have that?
It's 0320.
0320.
Yes.
Yes.
Right. Thank you.
Oh, yeah.
Richard came with foster mum. Why did you say it, etc. And then at the end of it, he took some money or something. I think I slipped and pulled the trigger. So thinking about that account. First of all, nothing was taken, as we know. But secondly, he thinks he slipped and pulled the trigger. It's very difficult to understand how someone who had slipped would still have managed to put a bullet almost horizontally into the head of the victim. Because if you imagine that he was there and he was holding the gun in a horizontal plane, if he slipped, surely the position of the gun would have moved and the direction of the bullet would have been different. That seems to be common sense, but if your lordships disagree, so be it. We say that this is a further indication that he was making it up. And he didn't say anything that I remember about slipping in the interview.
what is the note above that? Why did you say it, something inside me?
Yes, that must have been her question as to why he said it and what he replied.
Right.
Indeed, the typescript says, he told the police everything as something inside him made him tell. So we say there is further inaccuracy and further nonsense in the slipping story, which could not explain the injury. He was still wanting to say that it was an accident. It's very difficult to see how this could have been an accident. It appears to be completely deliberate. I take your lordships on from there. Sorry, I'm doing it again, the court. To conversation or conversations that he appears to have had in custody. Oliver told his solicitors on the 6th of August of 1991, according to an attendance note to which I could take you, that he had told a prison doctor that he'd been involved. Oliver explained, said the note, that the prison doctor had been asking him questions about the shooting. It appears that Oliver told the doctor during his first couple of days at Feltham that he'd been involved. He explained he was very upset at the time. However, since that time, he has persistently denied any involvement in the murder. So we can look at the original notes at CACD 1-1035. There are two entries for the 6th of December 1990. Of course, the interview we've just looked at was on the 2nd of December, the last interviews.
So page reference again, please?
Yes.
Oh, here we are. Thank you very much.
1035.
Thank you very much.
I was supposed to have murdered a shopkeeper along with my mate. I was under the London hospital when I had the brain damage. I was very young, probably no subnormal, no previous custodial experience. The phrase, I was supposed to have murdered a shopkeeper along with my mate, would suggest a denial, or at least no admission. And there are quotation marks in the phrase beginning, I was supposed. The second passage follows on immediately and reads, stated the shooting was an accident. His co-D had a gun as well, and no one was supposed to get hurt. He seems quite happy about being here. And then the next page, which is undated, under the heading impression, a simple-minded young man denies the offence but says he made a statement to the police admitting he did it whilst being held in the police station, Hackney. Again suggests the denial. The fourth page for 19th of March remains adamant regarding his innocence. But let's look at what appears to be an admission on the 6th of December. Supposing he did make it, it again was absurd. That two men out to rob off licenses would each take a gun is barely credible. Getting two guns would have been very difficult, and people who had access to two would be going after more lucrative targets like security vans. One gun would be more than enough to terrorize staff members at a supermarket at closing time. And you will hear from Professor Johnson tomorrow that it is not unheard of that people who have been inveigled into making a false confession continue to repeat it to others. It's not the normal pattern, but it happens. and he can give examples. So we argue about these admissions that the more different stories he has told, the greater one's doubts about the veracity of each of them. I was the lookout. No, I was the gunman with the string holster who'd hidden the gun in the field, or was it a forest? And I hired it for 2 weeks, or was it for 2 months? We took some money or something, and I think I slept. We were both armed. The more variations, the more one has reason to doubt that any of this can be true. I now come to another point, but a related point. We say that Mr. Ellison manipulated the situation in order to achieve an interview without a solicitor. And I will just, this is at page 412 to 420 of our appeal argument, and I will just give you very quickly the headlines of that. And it's right to say that the judge on the voir dire said that he had not done that and that he had behaved with integrity and propriety, but there were aspects that the judge was not referred to, partly, of course, for the very good reason that some of them would have been privileged. So the first point at 413 is that although Ellison told Mullinger that there would be no interview if there was no success in finding a social worker, he made no attempt to find one. And if he had made an attempt to find one, that would have been recorded in the custody record, because the successful attempts to find social workers on other occasions had been recorded in the custody record, as we see at paragraph 413. And there's a strong inference that Ellison did not tell the custody officer that another social worker was required, because at 827, the custody officer recorded, social worker has gone off duty and therefore cannot attend. He doesn't seem to have been told to look for another one. And thirdly, instead of trying to get another social worker, the police got Mrs. Jackson to come to the police station. Why? Fourth, why was she asked to see allowed to see Oliver alone? Fifth, why was he involved in the process at all? Sixth, the point we've already seen, that he doesn't refer in his notes to the occasion at 7:30 when he went to the cell to inform the subject that his stepmother had arrived. Seventh, why didn't Ellison contact Mullinger to explain as a matter of courtesy that plans had changed and Oliver was now willing to be interviewed without his presence? And finally, he didn't even call Mullinger until the following day to tell him that Oliver had confessed. So we say there is, at the very least, quite a heavy question mark over his conduct on that aspect. Then the next topic is evidence from the defense files relating to the police conduct. And the first is a point that I suggest is very telling against Detective Sergeant Ellison. Because the short point is this, that Ellison had interviewed a man called Richard Clark, who had given him some not very important information about Oliver. And yet Oliver knew about that information and kept on referring to it during his interviews. And the only explanation for that can be because Ellison must have told Oliver about Richard in one of the off-record interviews, never noted, never disclosed to the court. And you can see the detail of that, which is quite intricate, but I suggest very interesting and telling, at paragraph 458. Just want to check that I've given you the right reference. I've given you the summary, and I don't propose to say any more about it. Yes, it's 458 to 461. Then the next point at 462 we've already looked at, the unrecorded request by Oliver for Miss Marshall to attend the police station. And then 3 points relating to Mrs. Jackson. First of all, that Oliver had repeatedly insisted that his solicitor should not call his stepmother. So how willing was he to see her? And when she turned up, how did that make him feel? Secondly, paragraph 464, on the 2nd of December, Mrs. Jackson told Jean Eldridge that she'd got to the police station. She'd been asked to go to the police station at 6:10 and had arrived at 6:30 and no later than 7 o'clock. Why was she being brought there at all? It cannot have been because Oliver wanted her to come. That was the last thing he wanted, for understandable reasons. And then, paragraph 465 and 466, that Mrs. Jackson was saying that she'd been told by the police that Mullinger had been obstructive, which of course he hadn't been. This is all part of the ploy to get her to agree to help, unquote, by being the appropriate adult. Now I'm going to leave the rest of that because there are other points which go to Oliver's instructions that my Lord raised earlier that I want to deal with at a slightly later part of my submissions. We now come to the second aspect of all of this, what Eric Samuels had to say. And this again is quite a lengthy and complex saga. We have prepared a document that I hope the court has seen, which is the Samuels schedule, which summarizes every part of this, although we will have to go to some of the detail. I've got a reference for that.
My lords, my lady, this schedule is at CACD 1, pages 2128 to 2132.
Yes. Thank you very much. So we can, I'm hoping, if this is convenient, to use the schedule for most of my references, but then to take you to some of the original documents where we need to see the precise wording. So, the first reference, I'm afraid the print is rather small, is the 4th of December of 1990. Eric was arrested at Wormwood Scrubs where he was serving his sentence. En route to Hackney police station, he asked how police came to see him. He was told because police inquiries led to him. He asked what inquiries. Butters said, let's just say Oliver Campbell. He was shown a copy of the Sun newspaper of the 3rd of December and told, read that. Presumably, that referred to Oliver's arrest. And I don't suppose it was just a coincidence that the police happened to have it with them. He did so and paused for about 3 minutes, visibly shaken, and he then said, according to the note that the 3 officers made later, I'm no murderer. I couldn't believe it when he shot him. I didn't even know he had a gun. I never went in the shop. It was him who went inside. I was outside when he shot him. I couldn't fucking believe it. So who is the him and the he that is referred to here? The prosecution case was that it must have been Oliver. Well, must it? And if he said the guy, the chap, the idiot, rather than he, it would have a different sense. And why was he pausing for 3 minutes? We make this submission to the court, that if one imagines that Oliver was innocent, Eric would have been genuinely shocked to hear his name suggested as the person who'd actually been charged with this offence. And he would have been thinking about what to say. And he would have said something which made it clear he didn't know about the gun, but maybe he didn't want to be absolutely unambiguous about who had it. We simply don't know. One's impression of this must be coloured, must it not, by the fact that one knows that so often after this he exculpated Oliver. If you take it by itself, it's implicating him, maybe. But if you look at it in the round, it may achieve another significance. I move on, and we then come to something very remarkable, and something, again, I've rarely, if ever, seen, if I may say so. And that is the police encouraging Eric to adopt a particular line. And we have set this out at paragraphs, which I will give you in a moment. But the line that they were encouraging him to adopt was that Oliver was the gunman, and I, Eric, didn't know that he had a gun. And it was being intimated to him by Ellison and another officer whose name I forget, I think it was Butters, but Ellison certainly, that it would be to his advantage to say that repeatedly. It was being suggested. And I now have to find that passage in my note. Means my going back in my documents, forgive me.
It's paragraphs 188 to 93 of our appellant's argument, but CACD 1, pages 1816 to 1817.
Thank you, Ms. Slowe, to the rescue again. Thank you very much. Well, you don't need to look at all of that, but that's the gist of it. And the importance of it is that he, having been encouraged to do that, to say, oh, it was Oliver that had the gun, but I didn't know, he in fact did the opposite. Because if you would look at the schedule, please. This is serial 3 of our schedule. 7th of December, Eric wrote to Detective Superintendent Wilkins, who was in charge of this inquiry, asking for another interview in the presence of a solicitor ASAP. Serial 4, 5 days later, the 12th of December, Mooney of Prison Security messages police that Eric wants to see them urgently. Serial 5, on the 4th of January, sorry, the 4th of...
14th.
No, sorry. It's the 4th, it says 14/1/90, it should be 14/12/90. Apart from that, the schedule is immaculate. 14 December 90, Ellison and Butters visited Eric. He said he wanted to make their job easier and asked if he should see a solicitor. They suggested he should. So he's wanting to tell them something. And I suggest that what he wanted to tell them is that Oliver wasn't there. Because that is exactly what he did tell Mr. Cater. There. Yes. Because that's exactly what he did tell Mr. Cater on the 15th of December. And here I want to look at the exact words that Cater noted down. And we have produced, rather than go to the statement, it is easier to read our typescript, which we have checked for its accuracy.
The typescript is at K1, pages 44 to 50.
Thank you.
There is a hyperlink in the schedule.
What has happened here is that I think Samuels was being kept at Wormwood Scrubs, And on this day there had been an abortive identification parade to which Cater had taken Samuels, and so now they are coming back from the parade. And his record of this begins as follows. You have this: we left the identification suite with Samuels handcuffed to me and got into the rear of the bus. He asked for a light and was handed and given a cigarette. As we were leaving Brixton Yard, he said, "Why didn't it happen today?" "Because your brief didn't turn up." "They're fucking useless," he said. There was a pause before he continued, "So what happens now?" "We'll have to come back in January." "Did Oliver have his one?" "Yes." "Did he get picked out?" "I knew you were going to ask me that." "Did you?" "Yes." "Did he?" "Why are you so interested?" He didn't answer, and there was then no further conversation until he said, "I didn't want to go for no murder. Do you want to tell me about it?" "I want to." Cater, if you tell me anything, if you tell me, then anything you say I can give in evidence in court. You understand, don't you? That was an incomplete caution. Yes, there was a pause for a few moments, and then he said, "I was going to tell you before, but the solicitor told me not to." Well, it's up to you. Oliver wasn't there, wasn't he? No, it was someone else. Why don't you start at the beginning? There was 4 of us to start with. Who were they? The man Oliver. I met him up the West End. That's where I hang out and I see my friend. I know him by face and not his name. He was with some friend I've never seen before. So I think he's saying that the 4 were Oliver, Samuels, the man who he named later as Harvey, and a friend. What's his name? Harvey. Harvey what? I don't know. What happened? This Harvey said he wanted to do a rob. I said, "What you got to do it with?" And he said he had a gun. He showed me it was in a pouch. He put his hands down by his groin. He said, "We were in the street when he showed me. We started driving around Oxford Street looking for somewhere to rob. I said it was stupid to do it round there." "So you were going to take part in the robbery?" "Yeah." "What was the time when you were up around Oxford Street?" "About 6 o'clock." "What happened then?" The man Harvey asked me if I knew anywhere round my way to rob, and I said I might know somewhere. So we went to Hackney. I went into a lot of off-licences. I started in Cambridge Heath, which would be to the south of the supermarket that was eventually robbed, and went to all of them on the way up to the one we did. Where in Cambridge Heath? Near Hackney Road. Carry on. We went in and did it, and he fucking shot him. He's crazy. He's a crazy man. I've been done right up. How's that? Because he's a bad man, crazy man. What are you saying? Your friend knew he was a crazy man and didn't tell you? Yeah. But you knew he had a gun. He made no reply. What happened after you'd done it? He done it. He shot him, not me. Yes, after the shooting, we run out. Where did you go? To your dad's? No, I didn't have a key. I was living at my mum's. We went Clarence Road. How did you get there? Through the flats. Well, we know that was the route. Then what? We ran through the Nightingale to the station in Rectory Road and got the train to Manor House. Then what? We went up west to a club. Pausing there, Manor House is and then was on the Piccadilly line, and if you went a number of stops from Manor House, you would get to, say, Leicester Square or Piccadilly in the West End. What were you wearing? A white top and trousers. I can't remember what trousers. Well, the top was, in fact, a khaki top, the one that we saw dimly in the photograph of Arrows Court earlier. Where is the clothing now? I chucked it in the bin. It wasn't in a bin, in fact, it was by the car. Where? I can't remember. What club? The Warren. Where's that? Near the Cambridge. It's where all the prostitutes hang out. You knock on the door and they have a look and let you in. What did you do there? I saw my friend Mick. We didn't stay long, then we went to a club in Lewisham to sell the gun. Does Mick know anything about this? I told him we did a robbery, yeah. What club in Lewisham, I don't know. Who took part in the robbery? Just the two of us. What happened to Ollie and your friend? When we were up west, this Harvey taxed Ollie's hat, and he couldn't do anything about it, so he just went off. That's how Ollie's hat got used. My friend didn't want to get involved and went to the toilet. How can we find out who this Harvey is? He's wanted. I asked him why he shot him, and he said he was wanted, and he wasn't going back to prison. He's from Lewisham, or his women are. What's he been arrested for? He's done 7 years for armed robbery. He's a bad man. This ain't the first time he's shot someone. How'd you know? It's what I've heard. Where does he come from? Brixton, I think. What country? I don't know. How old is he? I don't know. He didn't say. Where is he wanted? I don't know. Brixton, I suppose. Have you seen him since the shooting? No, he just said, keep stum. What about your friend's address? I don't know it. Have you been there? Yes. Where is it? Round Lewisham. Whereabouts? I don't know the area. Could you point it out? Yeah. We'd arrived at Wandsworth Prison at 1:10 p.m. and he said, I'll write to you, I'll get my solicitor and make a confession. Well, he didn't. But that, we suggest, is a very plausible and even cogent account for a number of reasons. First of all, not only is he saying that Oliver wasn't there, but he's making a confession against his interest that he knew that his accomplice had a gun, the very thing that he'd been encouraged to deny by Ellison and his mate in the recent interviews. He knew then that the gun was in a pouch. And that little conversation, what are you going to do it with? He showed me the gun, is very plausible in my supposition. And then, did he invent the bit about the club where the prostitutes hang out and meeting his friend? Did he invent the bit going to the Lewisham to sell the gun? Which again, could get him into further trouble, he might think. All of this is plausible in itself. And if you ask the question, which is the more credible account, his or Oliver's, then it answers itself. So that is what he said on that occasion. Didn't he? Yeah. Thank you. Can we go back to the schedule, please? There was then, on the 20th, not surprisingly, the police sought to see him, as he had in effect said he wanted. He would see a solicitor and make a statement. But on the 21st of December, Serial 7, he was interviewed. He did not want to sign Cater's notes. His solicitor, Mr. Brennan, after a private interview, said that he'd advised him not to answer. On the 4th of January, this is Serial 8, at a remand hearing, Eric's counsel was rather vague, according to the attendance note of Ballinger Banks, but indicated his client had made statements to police that could be challenged as they were obtained in breach of pace. He said that insofar as his client had said anything to the police, he was saying that Oliver was not involved and had never been involved in any part of the murder. And our comment in the right-hand column is ambiguous. It may not be clear what Eric's instructions were at that time. Was counsel relaying his instructions, or was he simply relaying what he understood Eric had said to the police? I can't go so far as to say that he was relaying Eric's instructions. But there is no ambiguity about the next entry on the schedule, we say, and you have, of course, the references to all of the original documents here. It's on the 11th of February of 1991. At a remand hearing, Eric's solicitor was reluctant to discuss his detailed instructions. He gave the impression he would say another person fired the shot, and he gave police information about who that person was. The solicitor doubted whether the police would take any action on this, but Samuel said our client was not involved at all. So that, in my submission, is apparently relaying Eric's instructions. Then the next aspect in this saga is really, certainly from our point of view, extraordinary. Because having had papers in this case for over 25 years, I suddenly found in the spring of this year, quite by accident, as I was looking for something else, a further document which shows a very clear exoneration of Oliver by Eric in prison, possibly, perhaps even probably, to a member of prison staff. Let me, first of all, hold up the document. Might make it just a little bit easier. This is the original of some notes dated the 15th of the 9th, 1991, notes that Oliver's solicitor's representative made of a visit to him, and they are reflected, a number of them, in a note, a typed note that was typed up, dated, I think, the following day, the 16th of September. I didn't trouble you with that. On the back of that is a name Posner's, which may have been the name of the solicitor's firm at that time. There is then a letter dated the 30th of August, which was a very anodyne letter from Maria Marshall to Oliver, talking about having to change arrangements for an appointment to see him, or something of that kind. That is crossed out. And it's on the back of that letter that an anonymous letter is written to Oliver's solicitors, apparently. And then we have the rest of the attendance note stapled to the anonymous letter by a rather rusty staple. And I'm not giving expert evidence, but I've seen a number of such rusty staples on a number of other Mullinger Bank documents. So this is a letter written by someone, it appears, to be delivered to Oliver's solicitors. Let us, I'm being saved by throwing my papers all over the case. Let us look at the typescript of that letter, please. I'm sorry. Yes. You can see the original at page...
CACD 11028.
Thank you very much. And the typescript sorry, yes, oh, we have. Forgive me, I'm sorry. It's set out in our further submissions. I think we might have the...
At paragraph 17 of the further submissions, CACD 1, page 998 to 999.
Thank you. This is to whom it may concern. I have absolutely nothing to do with your client's case, but I wish to express an opinion as an outsider after having talked to him and knowing him in a short time in prison. I believe it will be a grave miscarriage of justice were he to go down on the very serious charges he's up against. I believe that he's been set up by his co-defendant. I say this because of the evidence against him. Firstly, he has pleaded guilty to the robbery charge against him. Pausing there, this must be after plea, which was on the 25th of December of 1991, as we know from court records. He's pleaded guilty to the robbery charge against him, meaning that he was against him stroke them, meaning that he was at the scene of the crime. Secondly, he was with Oliver the day Oliver, lost his hat. It is of my opinion that the hat was planted in advance. It stands to reason why the cap was found on the scene of the crime. In other words, it was planted there. The last thing any sensible criminal would do would be to leave something as distinctive as that cap behind, even if you had to run for it. According to Oliver, forensic tests on the cap prove that he was not the wearer of it at the time of the crime. His co-defendant refuses to go in the dock because that would leave him open to cross-examination, which would give him no choice but to reveal who his actual partner in crime is. He has admitted to us, plural, that he was not with Oliver when the crime took place, but refuses to go in the dock to say that, because in truth he is afraid of what could happen to him if he did reveal the person whom he was with. I do know that Oliver has made certain confessions to the police, but that at the end of the day, that amounts to nothing if you know his mental capacity. And finally, I wish to do this because as a black brother, unquote, I do not wish to see another brother go down for something he did not do, rightly or wrongly. Were Oliver to go down, then you as a lawyer don't deserve to be in the profession. P.S. Oliver's co-defendant has admitted to us, again plural, that Oliver was not with him when it happened. So, that is what that person was saying. So let us unpack the significance of that. First of all, as I say, it appears to be after plea. It is someone who is concerned because Eric has told us that Oliver was not there. The wording of the letter, which has a certain formality about it, might suggest that it's a member of prison staff rather than a fellow prisoner, but that is not certain. But what it does show is this, that it removes the sting against Oliver of the plea of guilty. It was a plea of guilty to conspiring with Oliver to rob. Because even after that time, Eric was telling people in the prison that Oliver wasn't there. I cannot explain how it is that it's attached, that it's written on the back of a letter dated in September. Well, that may simply be because the writer acquired that headed note paper from Oliver. What I can't explain is why it's attached to an attendance note of the 15th of September, because it was apparently written much later. We can't answer that question. We should not trouble too much about it, but it speaks for itself. And it also goes along with something else that we know about, which is that there was another person who was to say at a much later date that Eric had been saying in prison that Oliver was not with him, and that was the man Sanderson. My Lords, I don't know, I'm going a bit slower than I had intended. I don't know how long your Lordship would wish to go on this evening.
Well, we'll press on for a bit.
Sorry?
We'll press on for a bit.
Yes, thank you very much. So, sorry? Yes, Andy, thank you very much. Then we'll go to serial 11, going back to the schedule. And this is when he saw Mr. Bowden, Dr. Bowden, the man who thought, you remember, that he might have paranoid tendencies. And this was on the 2nd of November, 1991. Mr. Bowden, Dr. Bowden said he was not willing to discuss the circumstances surrounding the alleged offence with me. One wonders whether that was because he had not made up his mind as to what line he was going to
I'm sorry,
take.
Mr. Birnbaum, I've not interrupted you, but this is simply speculation.
So be it.
There may be a million and one reasons why he didn't
Yes.
want to discuss.
At all events, I will not pursue that. But that is what he said at that stage. And it was then on the 25th of November that he pleaded guilty to the closed conspiracy. Now then we go forward to 1994, because Sanderson's account did not come to light until the spring of 1994. If you look at serials 13 and 14, there seems to be a puzzle here, but I can explain it. 14 is dated the 10th of June of 94, and it's the date of Sanderson's statement for the appeal. But 13 is dated the 18th of May, when Ellison goes to see Sanderson, and it may be a puzzle why he's able to do that before Sanderson's statement is made. And I think that's because the CPS were given some prior notice of what was afoot by the new solicitors. I've seen a note to that effect, and so I say that in fairness to the CPS and to the police. So Ellison visits Eric at High Point at the request of the CPS for the appeal. Harvey was uncooperative and Eric was uncooperative and denied knowing Harvey. After some conversation about the gun, he got up and walked out. We don't know, of course, what Samuels was told about the purpose of the visit or what frame of mind he was in at that stage, but it appears clear at that stage that he denied knowing who Harvey was. Then we come to Sanderson's statement for the appeal. And can we look at that, please? This is dated the 10th of June. It is, we have the reference on the schedule.
It's Q1, page 26 to 28.
Thank you very much.
Thank you very much. I was convicted at the Old Bailey in December 1991 after a 3-day trial for murder. My conviction was quashed by the Court of Appeal and manslaughter substituted. I am at present serving a life sentence. He gives the prison. I was on remand in Brixton Prison when I met Eric Samuels. We came from the same area of London, so I became quite friendly with Eric. This would have been about August 91. I can still remember the first time I met him. We were slopping out on the wing. I got talking to Eric, and he knew a few people I knew, and he explained he was charged with robbery. He also explained he had a co-defendant, but the other guy was innocent. He told me a bit about his co-defendant and a bit about what had happened. He said the other guy had got involved because of a hat, and that this hat had been taken from the guy down in the West End. He explained that the police had exploited the guy for being so simple. My reaction was, surely the guy can't be so thick he's going to admit to murder when he hasn't done it. Eric replied, if you see this guy, he's really simple. He then went on to explain how the guy got arrested, and that this was because he'd been chatting up the girl in the shop where he'd bought it and given her his phone number and address. I couldn't believe it. I thought Eric was joking. The guy I got to know later, he's Oliver Campbell. When I saw Oliver, I realized what Eric had meant. It made sense to me that he could have confessed to something he hadn't done. When Eric was describing Ollie's hat being nicked in the West End, he said it was in Leicester Square. He said there was a group of them, but he didn't say how many, and that one of them had taken Ollie's hat. He said Ollie had tried to get the hat back, but the other guy wouldn't give it. He didn't say anything about the person who had nicked the hat. Similar comments were made to me by Eric Samuels at the Central Criminal Court when I was myself appearing on trial at the same time as his trial. So the similarities between that and the Harvey admissions and the anonymous letter that we've just looked at will be clear to the court. Please note that his account at this stage was that he had been told about this situation and Oliver's innocence, both at prison and then later at trial. He gave a somewhat different account, we'll see, when he was contacted by the BBC and went into much more detail in an interview that was recorded and which I'll take to you at whatever point is convenient. Of course, the court knows, and I shall deal with this briefly tomorrow, that that was regarded as hearsay by the Court of Appeal, as indeed it was at the time of the appeal, and was not admitted, and therefore did not form part of the court's consideration of the case, because it was simply excluded as being inadmissible. We then come, in this saga, to the BBC investigations. And this was in 2001, when the BBC discovered that Eric was a patient at Homerton Hospital. Attempts to see him were unsuccessful. Only his family was allowed access. This is serial 15. The BBC instructed Mr. Burton of Bullivant and Company to represent Eric. He made a statement to Burton. He, Eric, refused to sign it. His family, Burton, and his psychiatrist all indicated that Eric was prepared to help Campbell, but on his own terms. The suggestion that Eric might be paid was firmly refused. That is what Mr. Sculthorpe's statement says, he of the BBC. We don't know who was making that suggestion. Sculthorpe of the BBC interviewed Sanderson on tape, and he gave a detailed account of Eric's exoneration, but said that it had first occurred after he, Eric, had been acquitted. Sanderson indicated he wanted to help Oliver because he was believed he was innocent. So I would like to look at that and in a little detail, please, because it's the words that Sanderson said as recorded on tape, and it goes into a great deal of detail about the impression that he had both of Eric and of Oliver, detail that may be, I think, valuable to the court. Sorry. My lord, I'm sorry, I have lost this.
155.
Sorry?
Is this K155?
It should be if that's what the schedule says. My lord, I'm at a disadvantage in that I had marked up my hard copy, which I have mislaid. Would you forgive me for a moment? Yes, I have it. This is a lengthy interview running to about 10 or 12 pages, but we only need to look at certain parts of it.
This is at K156 to K164.
Thank you very much.
Yes. It's headed on the first page, Oliver Campbell, Toby meets Lloyd Sanderson, that is Toby Sculthorpe, a BBC producer. And I needn't trouble you about the first page because that is just background. But can we go to the second page, marked 2 at the bottom right-hand corner, at 0430. Toby, anyway, can you tell us a bit more about when you were on remand? Does the court have that? Second page.
Yes.
Yes. Yeah, I bumped into Eric Samuel and we got talking about his case. And he'd just come back from the trial and he'd been given a not guilty for the murder that he was on. And he explained to me that Oliver Campbell wasn't guilty, but the way, well, it's difficult to explain now, but the way he came across to me, you can only really express it in that sort of conversation. In that context, I could see he was trying to implore on me that, look, not guilty, he didn't do this crime, and I'm just sorry that he's going to get found guilty for it. He was almost certain that he would get found guilty, or at the time I think maybe he'd already been found guilty. So this is Samuel's, glad that he'd been found not guilty of the murder, but sorry that Oliver had been found guilty. Just talk us through that again, says Toby. How well did you know Eric at that time? Lloyd, I knew him just from in the prison, but because how we got talking was because he was from my area, and the incident happened round where I live, and obviously if you're in prison and you meet someone from your area, you're going to get talking. Whereabouts are you from? I'm from North London. I'm from Stoke Newington, but I used to hang around Hackney. And we all knew each other from certain haunts, you know. So I knew that area. I knew a lot of people that he knew, and we got talking about the area and whatnot. And obviously it moved on to his case, and that's how the situation came about, the conversation. What else? Is that the only time he spoke to you about the case? And he'd come back from trial? Lloyd, probable, yeah. There wasn't much to say, really, apart from when he came back, he was just relieved that he got a not guilty. But, you know, obviously he was sorry that Oliver was found guilty, but he felt he could tell me then because he couldn't be retried, and I suppose that's the reason I'm telling you what I'm telling you now, because I know he can't be retried. If I thought he could be retried, I wouldn't be saying this, to be honest with you. I know Oliver wants to get out of prison, and I do believe he's innocent, but I wouldn't sort of substitute, you know, help to substitute Eric Samuel in his position to get Oliver out. Okay, I understand that. I'll tell you a bit more about why we found out, just to ask you once more. So then I go to the next page, which is page 4. We've just been on page 3. where Lloyd gives a pen portrait or a verbal portrait of Eric at 11:44. Lloyd, Eric was the kind of person, because I consider myself to be back then even a little bit streetwise, Eric is the kind of person I would not have trusted not 1 inch. Obviously, I could speak to him from superficial, and I'll talk about what it was like living around that area, but there's no way I would trust him. I could just look at him and tell he was older than me, as well at that time. I'd just turned 22, and he was sort of the older kind of lot. The older sort of guy from around the area. He just looked like one of those guys that I'd just bump into at a gambling house or something, trying to sell me a dud draw or something, you know, a dud smoke. Honestly, he looked like that kind of person. I wouldn't really. What did he look like at the time? Yeah, he had a moustache and he had sort of a short afro, and I could imagine Eric used his head throughout the trial to ensure himself not guilty. I would have done the same thing in his situation, but like I said, he's not the sort of person that I trusted. And then Toby asks a few questions about how they knew one another. And a bit further down, do you see Lloyd? Yeah, we came from the same area. You know, he seemed to know a few people. I know. He seemed to know the area, and you know what sort of got me about Eric was looking at Oliver. You know, what would he be doing with him, do you know? I mean, what would Eric be doing with Oliver? No disrespect to Oliver, but if you was anyone outside, whether it be criminal or whatever, you wouldn't have him in tow. Do you know what I mean? So this is a criminal saying of Oliver that if you were another criminal, you wouldn't want to have Oliver in tow on a crime, as we read it. And then Toby says something about what Oliver has said to him. And I think that that is all I need. No, there is a further passage further on. No, there isn't. That is all. But I think that that is it gives the impression, although this may not be entirely clear, but it gives the impression on this account that he first knew of Eric saying that Oliver wasn't on the robbery after Eric had been acquitted. And the point that Eric would do, in effect, anything to get himself a not guilty is striking and no doubt accurate. Then back to our schedule. At paragraph 18, we knew that Eric had made a statement to the solicitor, Mr. Burton. After Eric refused to authorize its disclosure to the BBC, this is 18, Burton wrote 2 letters to Sculthorpe saying that Eric was frightened of comebacks from the perpetrator and that there was nothing detrimental to Oliver in the statement. I think we should look at those 2 letters, please, because they were rather striking. A solicitor going as far as he could to help us, as we interpreted it, but without perhaps going so far as to break privilege.
They are found at CACD 1, 885 to 886. It's in bundle 5, the Samuel's bundle of the appellant's bundles.
Thank you. So this is on the headed note paper of Bullied and Partners, the firm for which Mr. Burton then worked.
And in what?
I'm sorry, what?
In what capacity was Mr. Burton speaking to Mr. Samuel?
Ah, sorry. it did say earlier in the schedule, the BBC had instructed him to take a statement from Samuels on the basis that it would be privileged until Samuels authorised its disclosure. So they were keeping it an arm's length from Samuels and enabling him to have independent advice before he committed himself to anything that might disclose further criminality on his behalf. You may think...
I don't understand that.
Sorry?
I don't understand that.
Let me do it again.
Mr. What's his name? Mr. Burton, was he a solicitor representing the BBC or a solicitor representing
No, he
Samuels?
was instructed by the BBC to represent Samuels, to give
Samuel
him independent advice that the BBC would not...
Sorry, could you answer my question? Had Mr. Samuel asked for a solicitor to act for him?
No, but the BBC decided that they would not approach Samuel directly because they would be arguably inviting him to disclose further criminality. So in fairness to him, they instructed and paid for Mr. Burton to advise him so that Mr. Burton could tell him about the pros and cons of making a statement, and he would then, Samuels would then have the opportunity to decide whether it should be disclosed to the BBC. That was, in my submission, a very careful and fair way of doing it.
I'm so sorry, Mr. Birnbaum. I'm still struggling with this idea that there's a man who hasn't asked for a solicitor.
Yes.
But a solicitor is paid for by somebody else to go and represent him.
No, to go and advise him. He can say to the solicitor, go away, I'm not interested. That's the point. Or he can say, please advise me. Then he can say, I'm still not interested. Or he can make a statement and then be advised about the implications of disclosing it. It is done in fairness to Samuels. That's certainly how they viewed it, and it's certainly how we on this side of the case viewed it.
Right.
And indeed, the CCRC did a very similar thing. When they wanted, a little later, Samuels to speak to them, they didn't go to him directly. They instructed another firm, Scott Moncrief Harbour and Partners, to represent him. So there would be, as it were, a wall between them and Samuels, unless and until Samuels decided that he wanted communication with the solicitors to be disclosed to them. The CCRC did exactly what the BBC did in instructing Mr. Burton.
Mm-hmm.
And it was done, obviously, with good intention, I would say. The alternative was to go to him directly. He might just then say no, and that would be the end of it. Or if he said yes, he might incriminate himself, and that might create further difficulties. So, Your Lordships... Sorry. I'm sorry, what? Yes.
They haven't been individually copied. They appear in the body of the appellant's bundle number 5, which has been uploaded in full to tab 12 of the CACD1 section. The pages within tab 12 are CACD1, 748 and 749. The title of the tab is Bundle 5, Samuels.
So, this is a letter of the 25th of June to Toby Sculthorpe from Burton. Went to see Eric Samuels at Homerton Hospital on the 25th of June. I spent an hour with Eric and discussed matters with him in some detail. I read out the statement that he'd given me on the 8th of June with a subsequent amendment he telephoned about. He signed the statement confirming its contents were correct. However, at this stage, he does not wish for the moment to give an interview to the BBC because he's frightened that there may be comebacks from the perpetrator, nor does he wish to release his signed statement to you for information purposes until he's had a chance to consider the matter further. And then there is a further statement dated the 26th of June. Dear Toby, Eric Samuels, I refer to our conversation this morning. As you're aware, Eric Samuels has instructed me he does not wish to release the signed statement until he's considered matters further. However, I can confirm that there is nothing in that statement given by Eric Samuels that is detrimental to Oliver Campbell. I trust this assists you. So Mr. Burton was going about as far as he possibly could to assist the BBC and Oliver, but without disclosing the content of the statement.
Why is he going as far as he can to assist the BBC if his client is Mr. Samuel, who's given him certain instructions?
I think perhaps because he was acting out of a sense of justice.
Right.
I did speak to him at the time about this, but he was not able to tell me anything further than he had said in those letters.
Right.
So that is a further indication, albeit we've never seen the letters and they now no longer exist apparently, the letter, further indication that there was nothing detrimental to Oliver. And that indeed he had not been implicated. Then 19 is the occasion when, frankly, Mr. Maddox and I wonder whether we gave the right advice. And let me tell you about it, because Eric wrote to Oliver, and this is serial 19, on the 22nd of October. It's a long time since we last met. I'm now on a section 3741 of the Mental Health Act, and am in the final stages of a rehabilitation program. I hope to be out of hospital in the next year if things go well. So far, I've been in here for 3 years. Rough Justice contacted me this year, giving me a statement, asking me to give a statement on your behalf. Before I give this statement, I would like you to phone me on the number he gives. However, I'm willing to give the statement if it would help you out. On legal advice, Oliver declined. And that was the advice that Mr. Maddox and I gave, because we were afraid that in some way...
You do have to be careful about legal professional privilege.
We have put this in documents. I won't repeat it if you don't want me to, but I'm saying we advised him not to do it because we were afraid that he might be manipulated by Eric. Perhaps we could have been a little less cautious and could have organized a meeting that could have been recorded, and history might have been different. But I think I ought to say that in fairness, both to Oliver and to Eric. To this day, we wonder whether we could have arranged matters in such a way that they could have had contact and something helpful to Oliver and to justice might have transpired.
Right.
So then, we come to the next stage in this remarkable saga, which is this, that the BBC, having taken legal advice, decided that there was a public interest in trying to record covertly what Eric might say to a reporter, Linda Cowell.
Well, it's perhaps going to take you a few minutes to deal with this.
It is indeed, and it's very important.
So should we break off there?
I would certainly be very happy to do that.
Thank you. Can you just tell us, simply so that we know where we stand?
Yes. Well, I'm going to review everything overnight to ensure that I make it as short as possible, I'm not going to call the psychologist at great length. I will also liaise with the learned friend to make sure that I have the references properly somewhere near my fingertips, and I think we are on track to finish tomorrow.
Well, perhaps you can, for the moment, limit yourself to speaking about your case.
I'm sorry?
When do you think you will finish your submissions?
I think that our case will finish, including the calling of the two experts, which I would hope to accomplish. I think there will be little or no cross-examination, allowing about a half an hour for each of them. Let's say an hour and a half in all, as your lordships may have questions.
Yes.
I think our case will finish in the early afternoon of tomorrow, or possibly in the morning. I will aim for the morning.
Mr. Price, how does that leave you, given that the estimate has been set for the case and neither party has sought to change it?
If I have about 90 minutes to address the court, I'm hopeful that that will be sufficient. Could I add this, because it might help? As Mr Birnbaum has indicated, in fact, I don't propose, unless the court were to consider it my duty to do so in any respect, I don't propose to ask any questions of either expert. The court will have seen what is my submission in relation to the expert evidence. It's a matter of admissibility, and I wasn't proposing to ask them any questions.
Well, at some point, we're going to need assistance with submissions as to the legal principles.
Yes.
And one very important aspect of that is what's changed since either 1991 or 1994.
Yes.
And speaking entirely for myself, I do not find the answer to that emerges clearly from the many, many pages of the expert evidence now put forward. So somebody's going to have to clarify that. It may have to be the court if nobody else is going to ask.
My Lord, I will seek to address you on that question. It will be my submission that because of the form in which the reports are prepared, that change of circumstance is obscure.
Yeah. Well, Mr. Birnbaum hears that, and he'll be in a position to deal with it.
Yes.
And at some point, Mr. Birnbaum, you're going to come back to the question of what were actually matters in dispute at the time of trial as to what happened, for example, in unrecorded interviews and so on.
I'm sorry. Yes. You want to know
I'm not
what
asking
was
you
in...
to do it now. I'm
Yes.
simply reminding you that that's a matter to be dealt with at
Yes.
some stage.
Yes.
All right. Thank you very much. Well, we'll rise now. We'll sit again at 10:30 tomorrow. Thank you.